Anonymous appeal, Group 6, Lordship, without certified copy.
Why, sir?
Lordship, I am the retired employee, regularly concerned bank deducting my
What is the
pension.
date of the order?
9th February 2026.
Why you want to file without a certified copy? Get a certified copy.
Certified copy I have applied, Lordship, this still date not delivered. So,
What is the
Lordship,
point?
kindly only.
What is the point? Why it has to be filed for what?
Now, Lordship, I am a retired bank employee.
No,
Lordship, I am getting the pension from the EPFO as per the order of the recent judgment of the Honorable Supreme Court as per Regulation 2018 from the bank.
Yes.
Now, Lordship, the bank disbursing the pension, deducting the portion which has been given by the EPFO. And the EPFO filed a report that we have not given any authority to the bank to deduct my portion. But the Honorable Single Judge has refused to entertain the same. And
Or we are saying there is no urgency that something has
so,
to be
Lordship,
done.
my regular pension given by the EPFO has been regularly deducting.
Deducted, not stopped. So you can wait, get the
Lordship,
certified copy.
Lordship, this
Maybe 1 month. In the meantime, hardly 1 month pension is at stake. What is the big hurry? You file it with a certified copy. Yes.
Lordship, let me file, Lordship,
Not in a
let
routine way.
the procedure be completed. When I will move, I will produce the certificate.
No, sir, you do it properly, please. We do it. We allow it in an exceptional or urgent case. Yes.
May I be permitted to mention one matter? Sheets list item number 120
Yes.
for your lordship's maladies with regard to the recruitment of Constable West Bengal Police. Your lordship.
What do you want? What happened?
My lord, it is going down, my lord. Kindly take up. Otherwise, the authority concerned is going to publish the final panel. My lord, your lordship recollect the unauthorized changing of category. They have filed the report. In that report itself says that I have not changed my category.
Let's see how many cases we move today. Yes.
Kindly takes up on it.
With deepest of apology, my lord. This is a matter concerning original side, my lord. We were supposed to file written statements, my lord. We are late by a few days. It was all ready, my lord. Lord, maybe file this, my lord.
There was a time granted for filing.
My lord, we were supposed to file a few days back, my lord, but the matter is not taken up yet, listed, my lord. It was ready, my lord, but we have somehow missed it.
Have you served on the other side?
No, my lord, we will serve on the other side.
After you serve, you come. You serve, then you come.
My lord, by course of the day, my lord.
Anytime. If you serve it today, come tomorrow morning.
Great,
Yes.
my lord. Goodbye to you. Great.
Your Lordship, may I be permitted to mention two analogous matters, Your Lordship? They were supposed to be listed today. They were last appeared on 13th of February.
See, if it was supposed to listed today, why it is not there? Check.
Grateful, Your Lordship.
Get it on the next day. Why it has been missed? Yes. Get it on the next fixed day.
Grateful, Your Lordship.
Item number 1. My lord, with sincere apology, my lord, I have been instructed by my learned senior, my lord, that is a 2019 appeal, my lord. Therefore, my lord, the brief has been untraceable, my lord. My lord, some leave may kindly be granted to obtain certified copy. And it was untraceable since COVID period, my lord.
Not today. Come on the next day.
My lord, kindly consider one.
Sorry, we have seen the record. You make your arrangements. It can't be endless, sir. Call the next case.
Item number 3.
Paying for not this week.
You are for the respondent.
Respondent.
Why, sir?
Madam, my madam, only one not this week. Can you, madam? I am not ready. Can you, my lord? My relative was expired.
Why you are not ready?
Expired easily.
Hmm?
My relative was expired before. Relative was expired. Relative. Not ready. My relative one is expired. I'm not ready.
On the next day.
Yes, Madam.
You come on the next.
Item number 4, this is my application, Mr. Bandobad is applicant is seeking for 2 weeks time,
I am opposing.
There is some difficulty, he is in the other court, it is my appeal,
The last occasion your losses observed that this appeal has become infructuous. And how does an appeal lie by the inspector when state?
He was the party, he was the party in the writ petition. I will satisfy your lordship, on the next date,
What is the fun in keeping this pending?
I'm
For
sorry.
last 5 dates you have been seeking adjournment. Why do
because
you want
I-
to keep it pending?
No.
How does it serve a purpose by
I
staying
will
pending
tell you,
on the
lordship.
records?
I tell you, lordship.
Yes. Tell us how it is to be kept pending
Two
and
things
why it is to be
on,
kept
on,
pending.
on the pretext of 2 issues only. Some
We
adverse.
don't know anything. First, tell us what is the application. It is arising out of what? We have not seen anything.
This is
Every
Millard-
day you come and take an adjournment.
No, very well. Well,
They have
this
been
is
saying that everything is over. We have filed a charge sheet. This
charge
is
sheet.
what we have heard.
Correct.
We don't know what it arises.
Charge sheet has been filed. May I just submit?
Charge sheet, supplementary charge sheet, cognizance taken, documents have been inspected. Next date is 23rd February.
Yes.
And this arises out of which order?
But this is out of the order of from the single judge,
Let
whereby
us see where is that single judge order.
He is not challenging the appointment of CBI. He is challenging.
well, I am
Where
not
is the order?
seeking at the moment. I am
Come to the order. Come to the order. This is not appreciated that you will come and take an. Last day you got an adjournment even before it was called in the morning.
yes, my lord. I do appreciate, my lord.
This is not appreciated. Is it arising out of?
Get out from here.
Page 112. What was the direction which is being challenged? Page 112.
No, the present appellant is challenging for expunging certain remarks.
This is, my lord, all, my lord. This is the reason, my lord. There is some adverse remarks has been passed, my lord, against the, my lord, the investigation officer for non-arresting a, my lord, accused person. That is the, my lord, sole ground, my lord. The matter has been transferred to the CBI. Now, my lord, this is the domain of the, my lord, the investigation authority to, my lord, decide to whom they will take into the custody or not to take. Well, interestingly, my lord, the CBI has.
Where is the observation against you?
Millet, I tell you, lordship, it is 100,
Which paragraph?
110 now. Page 112.
112, the order starts. We are asking.
I tell you, lordship, millet. To the bit. 112. 112, the order starts. We are asking. 112. 112, the order starts. We are asking. 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 112, the order star
You don't even have the file today.
No, this is which Millard, the e-copy is there. Now kindly come to the Millard, paragraph 13, which
30
is
of the order.
115.
30 of the order.
Oh, yes, 13 of the impugned order.
13.
13. This is at page number 115. It is also submitted that the investigation officer may have been extremely diligent in the matter, but his hands have been tied by the power of the principal accused and other persons in power of the state. Under these circumstances, the truth may not be emerged despite the diligence and the sincerity of the investigation officer. The investigation must therefore be entrusted to an independent agency.
Yes.
Millard, this is Millard,
This
the
is
one of
only
the.
place. Is this the only place or anywhere else?
Sorry, Millard, no, there are. I will
First point out the various instances which you find are making an observation against you. You
Right.
are a party there?
Yes, I am the party.
Yes.
And
Which are
second
the
thing,
paragraph?
Millard, prior to that, only one thing Lordship would consider: the person concerned who has Millard the institute this writ petition is not the Millard complainant. Not at all the complainant. This is the subsequent issue. I would come later on. Now, kindly come, Millard, paragraph 6 onwards.
You are going in reverse.
Yes, Millard. I'm so sorry, Millard.
Yes.
Rather, Millard, the starts from the paragraph 5. The case was registered against the principal accused, one Taposh Shah, MLA of the Tehotto. He, Millard, subsequently died, Millard. The West Bengal and 3 others, namely Probir Koyal, Shamol Koyal, Sunil Mondol, and other sections 5 and 7A of the Prevention of the Corruption Act 1988. The substance of
So
the allegation is that
who has passed away?
the Taposh Shah, MLA, Tehotto.
He has passed away, and the other two are still. They continue to be accused. The other two continue to be accused.
Running into the course of the rupees from the various person, particularly from the complainant, promising job in the primary, secondary, and the higher secondary school in the state, has also been for the job of the fire service and health, etc. department of the state. The principal accused MLA was only issued a notice under section 41A of the CFPC, and other 3 accused were taken into the custody for the interrogation. The investigation has not been complete till date. Mr. Tiwari, learned counsel for the petitioner, would argue that from the very inception, the investigation was being carried out in the right earnest and the diligently by the IO Anupam Das, and his court is also indeed fined as such. However, the investigation reached to a stumbling block whenever it comes to a principal accused MLA Taposh Shah. Kindly note, Millard, these particular things, that the investigation was being carried out in the right and the earnest, diligent by the IO. Kindly note. Thereafter, Millard, the observation. However, the investigation reached in a stumbling block where it comes to the principal accused of the Taposh Shah. The court has considered the case diary careful. The said Taposh Shah has given a very detailed statement under 161 of the CRPC. However, to honor the truth, his statement alone is not sufficient. The investigation officer has not sought custody of the said Taposh Shah till date. Millard, kindly take this point also, Millard. Simply because of the reason, Millard, I have not, Millard, taken the Millard, the former MLA Taposh Shah into the custody. Millard, the court has come to that conclusion that I have to take, this is not sufficient. I have to, Millard, take the principal accused Taposh Shah for the custodial interrogations. Now on the second, Millard, in the affidavit in opposition filed by the investigation officer on behalf of the state, the reason for not taking the principal accused into the custody is contained in.
As far as this gentleman is concerned, these are hardly relevant today because he is no longer alive.
No, that's right. But this should not be treated as a principle because some observation may go against me.
No, there is no observation against you.
No, first 8, Lordship has seen the 8.
Yes.
The investigation is going in the earnest right directions.
Yes.
This is the observation of the court. Now, second, the investigation reached to a stumbling block.
8 is no observation of the court.
Now, the second one, Millard, the court has considered the
Yes.
case diary carefully.
Yes.
Taposh Shah given a very detailed statement under section 161. However, to honor the truth, his statement alone is not sufficient. This is, my lord, the findings.
So this
of-
is not against any person.
No. But
So this
the
is not against.
observation,
This was an observation.
observation of the,
And now it means nothing.
it means nothing today, but
Today.
yes, but this can be.
Where else?
Yes.
What else?
Now, the Taposha MLA Tihotta before the IO, this case in the basis of the notice accused under section 41 is CRPC. He was examined in this case and his statement was recorded. He was also submitted his clarification during the interrogation regarding the different date and the credit enters of the bank of account transaction during the alleged period. According to Mr. Tiwari, this is the position of the influence of the power that the principal accused holds and MLA. Mr. Tiwari, such it is submitted that the I am on the paragraph 13 that the investigation officer may have been extremely diligent in the matter, but his hands have been tied by the power of the principal accused and other person in the power of the state. Well, this is also the observation. The
This is an
principal-
observation.
with the
This is
court
an
has-
observation.
this is the court's record. The
This is an observation.
submission.
This is submission of
Submission.
yes.
Despite the diligent and the sincerity investigation officer, the investigation must therefore be entrusted to an independent authority. It is further argued that more than a year has been lapsed, and since the registration of the FIR, 3 other accused persons have been enlarged on bail after expiry of the statutory period. The investigation, which has been now turned ready and may have been come to a grading height, may become the infractuous and irrelevant if failed at the hands of the state ACB. The primary reason, therefore, is that the sitting MLA of the state legislature is the principal accused. I mean, this is also observation over here. Reliance is placed on the decision of the court in the circumstances when which investigation must be handed over to the independent agency than a
These are
state agency.
arguments, sir. Please,
No, this is, I am just placing, kindly bear with me.
when it says argued and submitted, how you are saying observation?
Reliance I am not saying, and I am.
No, before that
this is
paragraph.
further argued.
These are arguments being
Yes.
advanced and you
Further
are saying
is
it
the
is an
submission.
observation.
No, further is the submission, then is the argued. Net come.
Until now, you have not shown any observation.
Kindly come to this skip over the entire part. Kindly come to the paragraph
20, yes. Now,
based on the fact and the documents that have come to the record instant case, and already there is a CBI as above learned SG submit that the subject matter of the such and such vitally linked to the case already being investigated by the CBI. It is submitted by the learned ASG. There could be a conflict of interest if the state agencies are investigating into the allegation of the corruption against a sitting MLA. There should not be a conflict of finding between 2 different agencies in respect of the same crimes according to the learned ASG. The subject matter of the investigation into the current case being conducted by the ACB West Bengal is in the offshot, and the subject matter of the investigation being conducted by the CBI, which is being mentioned in the coordinate bench.
monitored by
Monitored by the coordinate bench.
which case is that?
Well, that is the job scam case of the school authorities. This is the other person was.
In which His Lordship Justice Basak's division bench passed the order.
This is the earlier. Yes, connecting.
one.
Yes.
And in that case, the CBI investigation was also being monitored.
Yes.
And what is the number of that case? And what is the date of disposal?
This I will be giving your lordship shortly. This is
Anyone of you know?
Primary recruitment scam.
Yes.
Where will that
People, please don't argue as if I know. I don't know anything. You have to tell me. Yes.
First, there was a recruitment scam of primary scheme and take volume. CBI investigation order was passed by the Honorable Justice Gangubadhai. Subsequently, the matter was taken up by different bench. Subsequently, two other matter was filed. In that case, CBI investigation and the investigations were ordered. This case is linked not only with the primary investigation, it's linked with primary, ICDS, racial delastion.
It doesn't seem so. From the initial paragraphs, it appears it is primary, secondary, and higher school. It doesn't look like it is for any ICDS scheme. Please see paragraph 6. Please read paragraph 6.
I have seen Marat. So can
Yes.
you come to the page number 1181?
Yes.
The court finding, paragraph 25.
Yes.
The court finding necessary for the purpose of instant case to set out a set out a statement of the investigation officer, one informed us, the petition before your lordship, made in the objection of the bail application filed before the session judge. What was the observation, madam? I'm placing.
We are just trying to find out when the honorable single judge has referred that it is being monitored, the same issue, in which case?
Currently, I am having the numbers of primary recruitment scam, Mani Bhattacharya's case, prime.
You will have to show us. We don't know. Speaking for myself, I don't know. If my brother may be knowing, I don't. So you'll have to show us.
Currently, I am not having the number of that particular.
Anyway, you don't even have the number as of now.
I have right now. I don't.
All right, you proceed then.
Mile.
You also don't have the number.
Well, I will be supplying it. Well, I will definitely. I'm on paragraph 25. This
No, you just completed 22.
Sorry, Millard.
You
Yes.
completed 22.
Completed 22. Then Millard, the citations of the learned ASG Millard. I am not over there, Millard. Kindly come to Millard. Paragraph 25. This court finds it necessary for the purpose of the instant case to set out the statement of the investigation officer one Anupam Das made in the objection to the bail application filed before the session judge. In course of the investigation during PC period of the accused procedural, such were conducted as per his statement in two places in his residential house, during such in his house of the village such and such, Tehotto district Nodia, in the first candidate in the group D and group C post health JCD under such and such department, and the list of the candidate for the examination of the West Bengal Excise Department, biodata of the one person along with the copy of the WBC examination admit card, important letters of the MLA Tapas Shah on his official pad address, the Honorable Minister Government of West Bengal Education Department of the such and such, Principal Secretary of the Government of West Bengal Education Department have discovered, and this contest role, involvement and nexus of the Probir with other accused person required to be verified further. During such in another house of the Probir at a village of such and such, PS Shampur district such and such, some appointment letter on the post of the LDC and the Department of the Agriculture, biodata of the different candidates, interview letter of the West Bengal Cooperative Service Commission, and the block letter and the pad of the MLA Tapas Shah of the Tehotto have been discovered on the basis of the statement of the PC accused. Such discovery leads to the evidence of the involvement and close association with the Tapas Shah, Mr. MLA Tehotto, for the commissioning illegal activities of the bribe collection on his behalf of the strengthening of the required to be verified. On interrogation, PC accused Probir disclosed that Tapas Shah MLA Tehotto as his personal assistant paid him salary rupees such and such cash per month. He was the personal secretary of the erstwhile MLA. And other expenses.
When you are reading the entire statement,
Yes, I am just.
we don't propose to stop you.
No,
But in paragraph 26, you see what has been taken note of by the session judge while passing the order. So that is part of a
The
judicial order.
observation of the session judge while refusing the bail of the three accused on the 2nd June also needs to be noted. Peruse the case record and the CD. On the perusal of the same, I find there are sufficient material against the accused person and the investigation in the nascent stage, and the main accused, who is the MLA, is not yet arrested by the IO. And considering the nature and the grave offense, also considering the stage of the investigation, I am not inclined to allow the bail prayer of the hence the bail prayer of the accused Shamul Koil stands rejected.
Yes. So
Now-
this is now finding in by the trial court also. that
Yes.
In view of non-arrest of this.
Non-arresting. Yes. Now kindly come the paragraph 28. The ground is
This also is in respect of that person who is gentleman who is no more.
no more. Yes. Yes.
Then what?
I tell you, Lordship, two things only. The person concerned,
Yes.
against him the allegation. I am basically not supporting anybody. I am the investigation officer. I have the wisdom to do the investigation. And the earlier occasion Lordship has seen this is the observation of the court. The investigation is going on a right track. But therefore on the basis of the statement and otherwise, to whom I will take into the custody and otherwise. This is completely the wisdom of the the investigation authority. Now let us come to the paragraph 28. The ground for transfer of the investigation from the state agencies to the central and for the independent agency, and the reason therefore have been settled by the Honorable Supreme Court in the number of decisions. One such ground for transfer when the investigation is being conducted against a person in power in the state, the ruling dispensation. There cannot be two investigations into one crime. It is how well settled that every investigation must be fair, transparent, but ineffective. Just an independent investigation must also be seen to be done in the eyes of the public at large. The faith of the public may not be there in the state agency investigation into one of their own person in a powerful position. An MLA of a ruling dispensation with widely substantial power and influence over the police machinery. It will therefore be incorporated for the state investigation agency to investigate into the subject FIR. Now, 31 is also not important, Millet. Now, Millet, paragraph 35, Millet, at page 128. Another reason for this court to consider the argument for the petition for transfer of the similarity between investigation into the current FIR and the investigation being conducted by the CBI in what is the commonly referred to the recruitment scam in the state. Admittedly, CBI has already filed a large number of the charge sheet. Kindly note that, Millet. Investigation is still going on and supplementary charge sheets are contemplated. Indeed, the possibility of the conflicting of the conclusions and the finding is likely if two independent agencies investigate into the FIR and the case there are similar and have been uncanny resemblance. An agency having already investigated into the same or the similar set of the fact crime may be better suited, equipped, and the experience to the investigate the subject SCB case number such and such. The possibility of this investigation being vitally linked to the pending CBI investigation is very high. The CBI has already found in incriminating the material against the principal accused MLA in the investigation already being conducted by them. Some powerful political person have already been taken into the custody by the CBI in their investigation. These facts are in the public domain. The likelihood of the conflicting finding between the state and the CBI in the instant case, if allowed to remain with the state agency, cannot be ruled out. As already indicated herein above, the investigation officer Anupam Das has already shown extreme diligence and courage in conducting the investigation. This court is of the view that such courage and diligence may have been fallen short when it comes to the principal accused. The fact in the case diary, those available in the pleading, definitely indicate so. Nothing prevented the investigation officer from seeking custody of the principal accused Tapas Shah after completion of the section 41A. The statement of the co-accused clearly and unequivocally indicated to the court the role of the principal accused. The court is the mind is not free from the doubt that investigation officer hands have been tied by the vested interest from the proceedings with the investigation and to take full circle of it. Millet, kindly pause here for a moment. Millet, the court in one hand observed the investigation officer has shown the extreme diligence and the courage to conduct the case. On the other hand, the court has come to a finding that so far the main accused Tapas Shah is concerned, its hands are tied. When it was come to the knowledge of the court, at the very nascent stage, when the two bail got cancelled, he has shown the case diary in that stage, Now kindly come to the paragraph 40. The court is also noticed there are three other accused. One of them is a personal assistant who received not only the salary allowances from the principal accused, but also, as per the investigation officer finding, handled cash transaction running into the several crores of the rupees. The letterhead of the MLA and his signature of such document have been disclosed by the co-accused. There is a substantial evidence and the reason for the investigation officer to have been taken into the principal accused into the custody. He has not done so despite having wanted to do so. This court is also Notice another glaring aspect of the matter. Although there are 3 accused who are not public servants, the state has not chosen to include any section of the IPC of the FIR. The IO doesn't appear to have been proposed to do so. There are other aspects of the investigation this court does not wish to discuss herein now. It may prejudice both the prosecution and the accused. The aforesaid observation made by the courts are only for the limited purpose of the arriving at the finding as to whether the subject investigation SEB case number such and such to be transferred to the CBI or not. The observation made herein should not be anyway be constructed to any final finding of the FIR. The truth will emerge only in the case of a fair and independent investigation. Such independent, effective, fair and sincere investigation is also a vital and essential perspective for a fair trial. For a reason indicated herein above, this court directs the SAB such and such under section 7 and 7(1)(a), the PC Act, read with section 1 such and such, be transferred to the CBI for the investigation. The investigation officer shall transmit all the entire case diary and all evidence such and such directly to the indirectly in his custody to the CBI. The CBI shall take over the investigation and conducted the same with the urgency of the diligence. The IO of the SEB shall cooperate with the CBI with the aforesaid observation. Now, my lord, this is the observation.
You are appearing for the IO.
I am appearing for this applicant, Millard. He is he was being arraigned as a party in the writ petition.
Which individual?
I'm sorry, Millard.
You are representing the one particular respondent there. from the
Yes,
writ
yes.
petition. Which respondent?
I tell you, Lordship, Millard.
Number 2 in the report. Page 30, you will also get.
Page 30.
303.
Yes.
He's the opposition. Oh, yes.
Yes.
Now, Millard, this is the sole observation made by
Where is that observation which pinches you? We are asking you again. Which paragraph? Tell
Millard,
us.
the court has come to a conclusion that although the investigation going in a right corner, but
That's not the point. You said that certain observation has been made against you. You are a party respondent.
right.
Where is that? In which paragraph which pinches you today, which you feel will hamper your
Fine.
prospect, career, anything which is without an opportunity? Where is that? Show us.
Millard, paragraph 38 is also there, Millard. Millard, just before that, may I make one submission?
Please try to understand what we are
Right,
wanting to
Millard,
know.
I do
We are
appreciate.
hearing everything.
I do appreciate.
What we are saying is you are representing an inspector who
The
was
inspector-
conducting the investigation.
Yes.
Now, where you are not a party by name?
No, I was not party by name. I was the investigation
It
officer.
is
I
a-
was
it
arraigned
is-
as a party in the writ petition.
Yes.
In the capacity
no,
of a
there is-
respondent, I have filed this, Millard, the app.
So therefore, there is no allegation against any individual.
No,
And
there is no
no
malice pleaded.
finding also
There is no
against any
malice pleaded in the writ petition, I would say.
and there is no finding also regarding any individual. The court has gone on 2-3 things as we have seen by now.
My lord.
One is that there is already a proceeding going on. The CBI is taking up the issue which is overlapping.
My lord.
To avoid a conflicting finding, and therefore two parallel authorities should not carry on the investigation. It says it is better that one carries it on. And then it also goes into the issue that since highly placed officials of the state are involved, it may be better that
To
it
hand
is
it over,
also
there is
to
no
the
conflict
CBI.
of other things. Yes.
That
Apart
is
from
the
that,
observation
apart
against
from
you.
that,
And if we are not mistaken from what is being submitted,
Huh.
it has been handed over, charge sheet submitted, cognizance taken. So what is to be done now?
I am joining
is
the
your relief
exactly,
today?
exactly I'm joining the issue.
Yes, sir.
Millard, the learned judge is of the findings that so far this
What is to be done now? You tell us.
I just kindly bear with me.
Don't just make a dissection of the findings. Now, in view of the subsequent events, that it has already gone to the CBI, charge sheet submitted, cognizance taken by a court, how we can unravel those things?
I am not seeking for anything. I am
Therefore,
seeking-
only one issue you may have is where is that observation which goes against your interest?
My lord.
We are unable to find it.
Millard,
We are asking you repeatedly to show where is that
Come
observation.
to the millet paragraph 38.
Yes.
Paragraph 38 millet clearly says, millet, so far the investigation is concerned, millet, this is going on a right track, but so far the principal accused is concerned, millet, this has been, millet, he is such a way, millet, monitoring or keeping the influence.
38, 39 you say are not only self-contradictory,
Correct.
but they are also leading to an inference or casting an aspersion on.
Aspersion only. This is one. Second,
Yes.
Lordship would kindly consider the two things. One, it was handed over to the CBI. CBI has filed the charge sheet. In the meantime, the CBI has not taken the accused person, MLA, in the custody for a time being.
That's not before us.
No, not before us,
This
but
hardly
this is the-
matters today.
very well.
Yes.
If that be the so, if today I am being guilty of not taking a person into the custody,
Who has held you guilty? Again, we are asking.
no, this is the aspersion has been made by the
Where
court.
has it been said that you are guilty of not arresting him?
Well, this is the observation that this
There
is
an-
necessary.
Please read again 39.
Well, kindly come.
You are
You
creating. a
already
question.
indicated here in above, the investigation officer,
No, no, place para 39 is the finding.
39. The court minds is not free from
Not free of doubt. There is
Yes.
no finding.
no finding.
So in the better administration of the criminal law, it says that to avoid a conflicting decision, and since it is already taken up, so many steps have already been taken in this regard. There is interrogation already going on, or everything has been noticed. So
Yes,
therefore,
that's
it has
true.
been
This
handed
has
over.
been-
There is
this
no
has been
finding
done.
against you.
But so far, Millard, so far this officer is concerned, he is being named over there.
You may think so about 39, 38, 39. We don't find it. We are
Millard,
being
this
very
is-
clear.
One second, Millard, kindly come.
Yes.
Courage to the conducting the investigation. This court is on the view, such courage and diligence may have been fallen short when it come to the principal accused. So far the principal accused is concerned, Millard, we have taken the steps, Millard. We have taken recorded the submission. The interrogations or the investigation is not, Millard, started with the custodial interrogation and ended up with the
Point
custodial
is,
interrogation.
today,
My lord.
what survives? Today, what survives?
But
Nothing survives.
I just want that this particular order for where Millard, the learned judge has come to a conclusion that so far the investigation agency is concerned is going on a right track, but so far the principal accused is concerned, he is fallen short.
Yes.
These particular observations should not be treated as a Millard precedent to that extent. This is one.
Is it required to be stated? You have just read the entire order, therefore we are.
Fine.
Is it required to be stated?
This court may have been fallen short. Come to the principle, the fact in the case diary and those available in the pleadings definitely.
Paragraph
indicate so.
42 and 43, does that leave it to any ambiguity?
For Lordship is referring, Millard?
42, 43, just
41
2, 3
and 40.
paragraphs thereafter.
Yes. This court has also noticed glaring aspect in the matter. There be 3 accused who are not public servant. This is Millard.
No, 42, 43.
42. Achha. There are other aspects of the investigation that this court does not wish to discuss here in now. It may prejudice. Well, I
No,
have
next paragraph.
43. The aforesaid observation might this court are only for the limited purpose of the arriving at the finding as to the whether the subject investigation in the ACB case ought to be transferred to the CBI or not.
That's all.
So, Millard, what is the finding?
The truth
Finding is
the
that
truth will emerge only in course of a fair and independent investigation.
true. Millard, where I have found the guilty because non-arresting a person. I am asking myself today, where in one hand, Millard, the learned judge has clearly, Millard, stated that this is going on a right track.
See,
I am once again repeating. I know, Millard, I am disturbing your
that,
lordship. Millard.
that accused, it says, has not been arrested.
Correct.
Other 3 co-accused have been granted bail.
No, he was the 3 other
Is this
accused.
a fact?
No,
Other 3 co-accused have not been granted bail.
they were in the custody.
But they
After
have been
that, they
granted
got
bail.
the statutory bail.
Then?
Statutory bail, Millard.
Because the charge sheet could not be submitted.
Statutory, yes, that's true. That's true, Millard.
So everything is being considered by the judge. It's not that only
So
because.
far, I am only to that extent, Millard. There are 3 points. If I summarize the same, one, the learned judge has come to a mind that there are several cases pending before the same issue. CBI is conducting the investigation. So thereby, this is the one of the point that if the state agency going on investigating the same, there will be a conflict of interest. This is point number one for the transferring of the same. Second, will not in order
Not conflict of interest. There will be conflicting outcome of the investigation.
yes,
There is no conflict of interest. It says two parallel agencies are investigating.
yes,
There is a possibility of two different findings emerging.
maybe
It's not a question of conflict of interest.
maybe Millard,
Yes.
maybe other conflict of the decision, I would say,
Yes.
to be very precise,
Yes.
Millard, conflict of the decision. Well, this is, I would say, this is apprehension to the point of the same, because we have not seen the Millard, the baby to be
Correct.
born.
It cannot, no finding can be recorded at this stage.
Right. So Millard, on that same, Millard, Lordship has also seen the Millard, the observation of the session judge, whereby the session judge said that this is absolutely on the nascent stage, and on the considering the same, I am not inclined to grant the bill. So therefore, the CD has sufficient materials to show that I am Millard investigating on the right track. Only not on, yes, I do understand, I do appreciate. In order to have the faith in the public at large, this could have been done into the CBI, but not to that point that not arresting a person, I will be found guilty to that extent, and this same would be handed over to the CBI, and the CBI will file the charge sheet. One more thing, Lordship would kindly note, there is a there is a Millard amendment. The person concerned who is giving the bribe and the person concerned who is getting the bribe is equally responsible. Millard, this is, we are also
That
investigating
issue does not arise in this proceeding.
that issue. Is
You are unnecessarily enlarging. It does not arise.
no, Millard, I just
It does not. The only issue was whether it is to be referred or not.
yes.
Nothing else.
Very
Nothing
well.
less,
Let us
nothing
be
more.
confined to that extent.
Yes.
Let us be confined
Don't
to that
enlarge
extent.
it unnecessarily.
Let us be
We are
confined to
not
that
going to
extent.
permit you to enlarge it. Be very
Millard,
clear. We are not going to permit you to
Very
enlarge the
lively
issue.
confining to
Yes.
the same. Millard, so far I am held.
You have said your only problem is with para 38, 39.
39.
That's all you are saying.
Yes,
And that is all open to you to argue as respond number 2.
my lord.
You cannot argue beyond that being a respond number 2.
Because I have filed the Millard the appeal.
Correct.
Yes, I do admit that.
Then other things you cannot argue.
I will not in that event. I have
A
been
question.
very Millard practical and very Millard
No,
technical
then
to that
we
extent.
have to take a legal view of the
The
issue.
Lordship is absolutely correct. I am not beyond.
We
I am
have
not traveling
We
beyond.
have to take
Yes,
a legal view. Of the issue.
technically I have to be there. I have been filed this particular Millard this appeal being a
Investigating officer.
officer
No
and
individual is here also. We
no,
don't
who
know
is
has
being
filed it.
arrayed as a party in the writ petition as well.
See, therefore, we are saying there is no observation against any individual.
True.
There is no observation against
True.
any. There is a
But these
general
two things
observation
would Lordship
of the circumstances which, according to the Honorable Single Judge, make out a case that the state should not be allowed to continue. So let it all be considered by the CP.
yes. So I have to be confined to the issue
We have
only to
understood
that
what you are saying, 38, 39, we have understood.
yes.
You say that in the same breath, the Honorable Single Judge says that in right earnest, everything is going on. And just because one accused has not been arrested, he thinks that everything is not right.
Watered down everything. Everything.
Not right.
Right.
Or
This
does
is
not
Millard,
appear
I am
to be
deeply
right.
obliged. Millard. This is what I am on.
And you are aggrieved by that because you are the investigating officer.
I am the investigation officer. This is all Millard, these two things which is troubling me. That is the Millard.
So,
That's all.
Yes,
If your
sir.
Lordship so desire, I would be Millard. I don't think.
if
Millard,
you desire, why should we desire?
no, I have
Whatever you want, you show us.
two things. I have to take the permission from the court because, to be very candid, Millard, I was empowered with certain judgments of the Millard the court.
See, we have heard you patiently.
I
We
know,
will see the
that is
judgment.
right. Millard, I have nothing.
So,
Yes, yes. But
you saw the judgment.
it is not with me, Millard. There are two, three judgments I would like
Fine.
to show, Millard. Any day, Millard,
So we
tomorrow.
will conclude your submission today. Mr. So-and-so, learned advocate, has made We'll consider that. The
coordinate bench while taking up this matter of Honorable Justice Chakraborty Chakraborty by order dated 20th May 2025 asked his client to show cause as to why documents are not handed over to CBI.
And that has been answered.
He is not pleading ignorance.
No.
he is only appearing for respondent number 2. He has a limited scope to argue.
Exactly.
He has fairly acknowledged that scope. He has made his submissions. We will consider.
My
There
lord.
are two things.
That's all.
One is state has not prepared an appeal. He is an officer of his
That's why we asked.
Yes, I have a very limited.
Therefore, we said,
and the main accused Tapasya has also not prepared an appeal.
no. Therefore, we said neither state is in appeal nor the individual investigating officer.
Yes.
But he has filed. We have to pass an order, whatever it is. We'll consider. Yes. And we'll, after hearing you, we will pass the order.
Let it retain his position.
But there is another aspect in the matter. Even if the order passes the line finger, he did not hand over the file from there out to you.
That's not, see, that's not an issue here. Not here.
No, not here.
But that can, we have not allowed him to enlarge. We will not allow you to enlarge also. We will confine only to the issue decided by the honorable single judge. Nothing less, nothing more.
I just point out the conduct of this one.
The subsequent event we will not take into consideration. We are being very clear from either side. Yes.
Item number 5.
Lordship has heard this matter, my lord. This is with regard to filling up of water body. That Inland Fisheries Act, the book was not there last day, my lord, before Lordship. Section 17.
Yes, let us see.
The state and the municipality both filed the report.
What are the kind of water bodies amenable to this act? All water bodies.
All water. All water bodies.
Within a particular geographical area.
My lord, there are competent authority within particular geographical areas, because in this municipality there are competent authorities.
No, this is for Calcutta only or for the entire West Bengal?
Entire West Bengal. No, West Bengal Inland Fisheries, entire West Bengal. But only, I think, my lord, subject to correction, my learned friend, only with regard to wetland, this particular law is not applicable, because there is a special law that is called East Kolkata Wetland Management Authority. That is different.
And this is applicable for which lands?
All other lands which are, my lord, water bodies, except that East Kolkata wetland. Because that is a particular law which is based on Ramsar Convention and all. I mean, already quoted.
Which act are we examining? This is East Kolkata Wetlands Conservation.
We are examining Inland Fisheries Act. But I think if
All
your
right.
worship has this
Yes,
book,
yes,
at the end,
at the end.
it is there. Section 17 तो already quoted.
17 सर आपको क्यों नहीं?
आते कुछ नहीं.
There is an act for protection of trees also in non-forest area. And in all these acts, the municipal commissioner is the competent authority.
Inland Fisheries Act with the municipal commissioner is the competent authority.
In this trees,
Commissioner is not
Trees,
there. In
well-
municipality there is no commissioner.
Uh,
In
yeah.
municipality, in municipality there are the
Executive officer.
executive officer.
Executive officer is the competent authority.
In
I've got this notification.
In other
executive
areas,
officer and mayor in council.
Mayor in council is for the corporation.
Corporation, Kolkata municipal. This is municipal.
Not Kolkata, Asansol and all everything. Kolkata is
Huh.
and my lord, in other areas, my lord, somewhere it is my lord the director of fisheries. So it is by notifications. Those are there.
So competent authority is not fixed in every area.
No, it's not fixed.
It's not
By
fixed.
notification.
So
my lord,
it has to be a competent authority,
Yes.
and the competent authority must be specified to be a
Notified.
particular rank,
has to be
and he
notified.
has to be notified.
In terms of section 2, clause 3, my lord.
But in the case in question, it is the executive officer.
Executive officer. Executive officer. Lordship, may kindly recall, my lord, I have said candidly that we have not
Yes, yes,
followed.
we remember.
We have not followed section 17 of the Inland
We
Fisheries Act.
remember. It is only an issue of cost.
Cost. I am only on the issue of cost.
আমাদের এখানটা established on All water. এটা preamble. পুকুর মানেই মাছ। পুকুর মানে কি মাছ?
And who is the appellate authority? Who is the appellate authority?
Section 19.
18 provides for appeal, but before whom?
But Deputy Director of Fisheries. That he has to be appointed by notification. Lordship may kindly see 18.2. 18.2 an appeal under subsection 1 shall lie with such officer not below the rank of Deputy
That is
Director
the
of
rank.
Fisheries as the state government made by notification of.
So though, although you are the entire repository of all the power, but it is to be done after a notice.
Section 17 says so that I have to notify him. Thereafter, my lord, I have to take steps, which I have not done. There were two reports, my lord. Your lordship may kindly recall. One,
Yes, one by the police.
municipality and one by the police.
One by the police.
And one by the municipality. The police had raised, my lord, objection with regard to the ownership based on the version of the trust also.
He had recorded that there is a dispute going on regarding
The
ownership.
trust and the petition.
That was not the submission of the trust.
That was not, sir. That you said on the last.
The trust never said so.
Hmm?
The trust appeared before the honorable single judge. It was not their case.
And you are for the
I am for the
owner,
owner of the
owner
of the
claiming to be the landowner.
Yes.
Yes.
But that is.
We have heard the parties. This is our book or your book?
It's much.
Instead of 6, make it 9.
9th. Yet to. Lordship has recorded my submission. Lord, in fact, I also made submission that they are guilty of filling that particular water body.
Add one submission.
That I'm appearing for the respondent repetitioner.
There are defects. What are the defects? You don't know. The learned advocate appearing for the yes.
Learned judge is not taking up.
We don't know of any such law, sir. We have not passed any stay order.
No.
Yes, call them. His appeal is not even in order right now. What more do you need?
That's it. Yes. DPM.
And number 7.
Matter was heard by your lordship for 15 or 10 minutes, my lord. Your lordships were in hurry on that day in the evening, my lord. It's regarding removal of pay anomaly, my lord.
At the end of the day, we were hearing.
Yes, pay anomaly. At the end of the day, your lordship was. But, my lord, today, my lord, I will be seeking
Appearing.
some time, my lord.
Petitioner, my lord.
Writ petitioner, I mean respondent, my lord. He's the respondent. I'm seeking time, some time. No.
So that the matter can be heard out.
Let it be fixed, my lord. I also, my lord.
Yes.
No, he resigned, my lord. Not retired, he resigned, cessation.
Whatever it is, nobody can have a dispute that it should not be expedited.
Yes, yes. I am not onto that. That I am not saying that is not.
Yes,
What I am praying with your lordship today. If any date subject to convenience of your lordship, and the next
Any
week
date in the second week of next month. Before that, we will not be in a position.
Any date, my lord. If it is, it can be fixed at 2.
If you will
2 PM.
agree to a date, then that will simplify
Any
things.
day, my lord. If it is the special.
No, my lord, that, my lord, I cannot oppose, my lord. Only, my lord, kindly fix it.
No, you tell us.
So that the matter can be.
Any date, my lord. As
This is the intra-court appeal is coming up on which day?
Second week of March.
We can have it on 11th.
We'll
have it on 11th.
Yes, my lord. Except Wednesday, my lord. 10th, 12th, 10th. No, 11th, my lord. What happens, my lord?
Is the date of this court now.
That is
11th, my lord. If it is at 10:30, I have no problem, my lord. And it's in the morning, my lord.
in the morning.
Morning, my lord.
All right,
The
we'll
second
fix it
half
at
match
the
will
top.
actually original side.
We'll fix it at the top.
Yes, my lord. Yes.
Let the matter be listed.
ওই দিন করে দিও
হ্যাঁ আমি এক সেকেন্ড আমি নামটা দিয়ে নি করো নাম্বার 7
I appear for the appellant.
I appear for the writ petition, the respondent number 1. I'm he's on his way.
This my lord was mentioned before your lord.
Acha, this is that matter which you were mentioning.
Yes, urgent hearing.
What he is doing in names that you are so
That's true, my lord.
disturbed.
That apart, this particular appeal, this particular appeal actually warrants lordship's interference on several grounds. Firstly, we are fully covered by my Lord Mr. Sri Madhuresh Prasad's judgment. But the right of an employee who is on deputation, recent judgment of my Lord. That number one. Number two, right of an employee on deputation. Your Lordship has delivered a latest judgment. He has no right, referring to some Supreme Court judgment. I am armed with that judgment. Number one. Number two is that the learned judge who passed the interim order had no determination. That fact was not brought to his Lordship's notice, but it appears, and is well settled under the jurisprudence, that even if something is not cited from the bar, it is the learned judge's duty to find out whether he has determination. Because your Lordships are aware, 1998, Volume 1, SSC, page 1, the celebrated judgment of the Supreme Court determining the issues of determination. Number one. Then I brought it to the notice of the learned judge at the time of extension of the interim order on two grounds. The appeal is pending before your Lordships.
Yes.
And your Lordship has no determination. Now, his Lordship observed that issue of determination shall be taken up at the time of final hearing of the matter. And recorded, unfortunately, that this issue was taken up by us, that his Lordship has no determination. Even then, he extended the interim order. And up to 31st March. Second. Third is, my Lord was just asking the learned advocate appearing for the other side, whether when an appeal is pending, either contempt or anything can be taken up. Supreme Court categorically stated, I have armed with the judgments of this court and the Supreme Court, nothing can be taken up without the leave of the appellate court. And learned judge has extended the interim order. 3 points. Number 4, it is a question of the right of a employee on deputation whose service is retained in the original employment at North Bengal Krishi Vishwavidyalaya as assistant registrar. That is not abolished. That right is still there, and the letter of appointment clearly stipulates.
Yes, we are listening, please.
Letter of appointment clearly stipulates that this period of deputation is for a period of 3 years or until further orders. Kindly mark it. Therefore, and in a given situation, what happened? There were certain disputes between the writ petitioner and the AIMS authorities regarding his payment and salaries of which is to be disbursed by the erstwhile employer or the present employer. He tendered resignation from the post of registrar. And that was not immediately acted upon, but it was categorically communicated to him that the question of his repatriation is being taken up. And ultimately, he was released. The learned judge passed the interim order of the earlier part, did not stay the order releasing him from the duty of the registrar. These are the issues I'll be addressing before your Lordships. Firstly, before coming to your Lordships' own judgment, I'll be heavily relying on that same. Kindly allow me to place what is the constitution of the AIMS, whether this is a service matter relating to Group 6 or it is an educational service matter or educational matter under Group 2.
What was the challenge before the Red Court?
The challenge was the order releasing him, and his resignation has been accepted subsequently. Says he has an indivisible right to continue because he withdrew his resignation.
Can you point out the impugned order before the Red Court?
Yes, I'm coming. I'm coming to that. Kindly come to the detailed interim order.
No, the impugned order before the Red Court.
Yes, page 38. Page 38, your Lordship will kindly allow me to place. No, sorry, I'm sorry.
14 of the can 1 will not.
14. Page 14 of the can 1. Yes, the can 1 to go. No, the can 1 down.
My Lord is looking at 109. 109. 6th of November 2021.
कोई देगी? वहाँ जाओ. Should I read the entire judgment?
No, no, sir. We are asking what order he challenged before the writ.
Yes. At page 14.
109. 27/10/25 order.
Yes. কোনো কিছু সাজানো করে নিয়ে এসছি রিট পিটিশনের প্রেয়ারটা দেখুন subsequently my lord he filed a supplementary affidavit challenging the order releasing him.
Where is that? Which
Yes,
page?
that is your lordship will kindly find.
And you have been there for how long? You have been there for how long? Since when?
My initial, for about 1.5 years.
Your Lordship, supplementary affidavit is at page 122 and the order is 31st October is at page 124.
Yes, page 124. This is order of the order dated 31st October 2025. He has been released. Earlier order was there also for repatriation to his original post. Therefore, no prejudice is caused to him either under Article 16(1) or any other terms of condition of the service.
So these are the two orders which are pending consideration.
Yes,
before
pending consideration before the learned single judge was.
So one is that his request for continuing his deputation has been rejected. And the other is the relieving order pursuant thereto.
No, that apart, he is also challenging his resignation letter, which was not accepted immediately by us and subsequently accepted. And before that, he withdrew this resignation letter. Therefore, he is relying also on this, that since his resignation has been withdrawn, he has a right to continue.
No, can he resign from a authority where he is on deputation, or he has to resign in his parent?
Exactly, my lord, the thing I'm harping. And that apart, I am fully covered by your lordship's judgments. Exactly, your lordships had been pleased to decide that issue. What is the right of an employee who is on deputation? That about, my lord, kindly allow me to place one by one.
Just one more thing. Please show us the prayer of the writ petition.
Yes,
please.
Prayer of the writ petition, my lord, kindly find. My lord, kindly come to page 50. Page 52 is the original prayer, is continuing. First prayer is dispensing with Rule 26. Prayer B is more concerned. Magnanimous, rescind, withdraw, forbear to give effect to effects of the order dated 27th October 2025, whereby the petitioner's prayer for withdrawal of the resignation has been rejected. This is the main prayer, not the releasing order. 27th October 2025.
109.
That is at 109, page 109. Then we will not see another writ of certiorari for quashing. 8th August 25 order, 4th October 25 order, 27th October 25 order. Not this here also not a releasing order. There they incorporated by a supplementary affidavit subsequently before the learned judge, and that has not been stayed. What page? 109 kindly come once in the list, my lord. This is 27th October 25.
Yes, we have seen that.
Yes.
We have seen. 109 and the other order we have seen, which is at 124. We have seen.
Now, my lord, may I just formulate these 4 questions which I have formulated? Lord, kindly come to page 126. Page 133, relevant portion. That is very important.
133.
Yes. This terms of condition of the service. This is premature division of department and deputation is to parent cadre. Normally, when an employee is appointed on deputation, foreign service, his service are placed at the disposal of the parent ministry, department, organization at the end of the tenure. However, as and when a situation arises for premature reversion to the parent cadre of the deputation, his service could be returned after giving a notice of at least 3 months to the lending ministry, department, organization as the employee concerned. Now kindly come to the appointment letter. That is also very important.
It appears to be a verbatim provision we had considered in that.
Exactly in that judgment.
I don't know if it is the same, but it is.
I am coming to that. I am coming to that. Kindly now come to the appointment letter. The appointment letter says his period of service on deputation.
Which page, sir?
This is, my lord, kindly come to page appointment letter 1st August 2024. That is, your lordship will kindly find at DOPT, and 16th July 2024 at page 76. What are they? 72 কিসের? এই আমাকে যে কাগজগুলো দিচ্ছে সে কিছুই মিলছে না। আপনার 72. This is clearly stipulates the appointment letter for a period of 3 years or until further orders. That is stated 1st August 24 order the letter of appointment. 1st August 24. My lord, then my lord, kindly allow me to place the other issues. The learned judge was completely swayed by the issue that since his resignation has been withdrawn, he has a right to continue. And unfortunately, the learned judge was going to set aside the order and dispose of the writ petition. He has recorded that. Initially, I was inclined to set aside the order, dispose of the writ petition, and just because I prayed for affidavit's time, kindly, as a kind of mercy, his lordship has given me the liberty to file affidavit. I was inclined to dispose of the matter. Now kindly come to the 3 issues. Kindly allow me, my lord, to place, because this is a very vital issue. The question of determination. There are 2 judgments. I had the privilege to argue one of the Honorable Acting Chief Justice Division Bhaskar Bhattacharya and the Honorable Chief Justice P. Desai judge. If a Honorable Judge has no determination, his order is not only a nullity, it has to be set aside forthwith. Your lordships are aware, following Supreme Court. These are the 2 judgments, and kindly see the determination. Yes, my lords, kindly see. I think this, my lord, kindly see. Appellate side rules of 226 was amended in 1986, giving the determination to the honorable judges. Group 1 is talks about land matters. Group 2 about the education matters. This is very important for us. Matters relating to educational institutions, including service matters relating to such institutions, may be divided under the following heads: recognition and derecognition, supersession, approval, disapproval, orders of appellate committee, dispute concerning admission, managing committee in consultation, powers of different authorities, miscellaneous. These are the heads of the education group. Now, my lord, kindly come to group 2. He says matters relating to educational institutions. All matters related to educational institutions. Now, whether AIMS is an educational institution or not, that has been clarified in the AIMS Act, clearly stipulated. They are offering degrees, postgraduate degrees, undergraduate degrees. And this post, my lords will kindly appreciate, this is the post of a registrar of a university, not the post of the registrar of a particular service organization. The registrar of a university, this post he was holding. Now kindly come, my lord, to the AIMS Act. The AIMS Act. AIMS Act. Sorry.
So the honorable single judge's determination according to you is group 2.
Group 2. That fact was brought to his lordship's notice on the time of extension of interim order. And his lordship said interim order is extended even if it is recorded that his lordship has no determination.
What is the determination in the list?
The determination in the list. His Lordship assumed jurisdiction of Group 6. Oh. That is why it is before your Lordship Group 6 appeal. But it is clearly stipulated in All India AIMS
So
Act.
we have seen the grouping, but we
Grouping.
have not seen what was the determination before this honorable single judge on that day.
All matters relating to Group
Where
6.
is that? It must be on the list. Please show us. You are taking a ground that he was not having the determination.
It is true. His Lordship's determination is the list of the.
We have considered another case like this. They had given the printout of the list of that day.
No, I am assuring your Lordships on that day, his
but we
Lordship
want
has
to
no
see-
education matter determination.
Just want to see
I am showing to you. Huh?
what he was having group 6.
It is a fact that you are having group 6 and you know we are.
Very well. Then there is no dispute. Then we'll hear you. Yes. All right.
Yes.
Group 6. Very
Group
well.
6. Now, my lord, kindly see what is the constitution of the AIMS body, whether it is in university, educational institution, or any other proper. এটা দিন তো জজ। My lord, this is AIMS Act. An act. This kindly comes straightway to section 13 and 14 of the act. Sections 13 and 14 of section 14, 13 and 14 my lord, of the act. Kindly allow me to place. As you lordship got it, section 13 and 14 of the act. These are institutes of national importance, which finds place in list 1, NT 63, 64 and 65 of the Constitution. Institute of national importance. Now kindly find section 13, object of the institute. The objects of every institute shall be to develop patterns of teaching in undergraduate and postgraduate medical education in all the branches so as to demonstrate a high standard of medical education to all medical colleges and other allied institutions in India. B, to bring together in one place educational facilities of the highest order for the training of personnel in all important branches of health activity, and C, to attain self-sufficiency in postgraduate medical education. Everything is about education. Now kindly come to section 14. Functions of the institute. With a view to promotion of the objects specified in section 13, every institute may provide for undergraduate and postgraduate teaching in the science of modern medicine and other allied sciences, including physical and biological sciences, provide facilities for research in the various branches of such sciences, provide for the teaching of humanities in the undergraduate courses, conduct experience and all that. These are all educational matters. And that is why his designation is registrar. Registrar of a university, we have also studied in the university. All universities are having the post of a registrar of an educational institution. Yeah. Now, my lord, the learned judge has said this fact was not brought to his lordship, and while extending the imprimatur, his lordship ought to have, on that issue, heard me on the issue of determination, which is lacking on that date itself. And this is absolutely perverse. His lordship extended the interim order till 31st March without deciding an issue which is raised from the bar. Now, my lord, the third aspect is his lordship said it was not brought to his lordship notice. Under the jurisprudence, my lords are aware, all questions relating to the honorable judges' decision making has to be done by the judges themselves, irrespective of the fact that it is cited or not cited from the bar. Otherwise, judgments remain par in curiam. Not only reference to a judgment, but other issues. And having that, when it is brought to his lordship notice on the subsequent date, was it not the duty of the learned judge to decide that issue without extending the interim order? That his lordship has no determination. Appeal is pending before your lordships. That fact was brought to his lordship's notice. Now comes the moot question, even if I have not cited on that day, or the very first day of passing the interim order, that his lordship has no determination, and his lordship has recorded. Your lordships are aware, Supreme Court has time and again said, question of law can be agitated at any stage of the proceeding in any forum, either higher forum or a coordinate forum, any forum. 1977 Supreme Court, AIR, page 5, clearly demonstrates this can be raised at any forum. Therefore, my lords will kindly allow me to place two division bench judgments, one of which I had the privilege to argue, and the other is of the Honorable Chief Justice P.D. Desai, where their lordships has been categorical in finding if determination is not there, the order has to be set aside immediately because it's a nullity. And that question can be raised in the appeal court also without going back to the learned judges court. That can be. This is also the finding of the division bench. This is, my lord, actually 2010 volume 1 CHN page 657. Dekhi. Santosh Kumar Singh. Now, this is the Honorable, the Acting Chief Justice, as his lordship then was, sitting with my lord Mrs. Prosenjit Mandal. I had the privilege to argue. Kindly come straight away to para 14, 15 and 16. 14, 15 and 16 of the judgment. Okay, after that, 14, 15 and 16, my lord, may I read? We thus find that the learned single judge should not have entertained the writ petition application if his lordship intended to exercise jurisdiction for non-compliance of the provisions of West Bengal Mines and Minerals Rules 2002. Moreover, we also find substance in the contention of Mr. Chakrabarti, that is myself, that simply by relying upon a report given by a particular officer of the state government, a court, without giving opportunity to the person affected by such report, should not dispose of the writ application. On that ground also, the other impugned order cannot be supported. 15, we thus find that in the present case, the order impugned was passed by the learned single judge having no determination to take up the matter, and on that ground alone, we set aside the order without entering into the merit of the writ petition application as to whether the applicant had a valid query permit or not. Para 16, we thus set aside the order impugned in the above ground and remand the matter to the learned judge having determination to take up the matter. This is done at the appellate stage, not before the learned judge who passed the order having not determination. But the appellate stage, it can be done without going back to the learned single judge who has no determination at all. It's a nullity. Then, my lord, the judgment of Honorable the Chief Justice P.D. Desai, as his lordship then was. Kunta. Anonyota. Ha. Kunta. This is, my lord, actually 1989 volume 2 CHN page 474. Huh? Ah. This is also good. This is the Honorable the Chief Justice of this Honorable Court, sitting with Mr. Justice Samuel Kumar Sen, as his lordship then was. Page, my lord, 26, para 26, 27 and 28. Para 26, 27 and 28. May I read it, my lord? By the notification issued on March 20, 1899, it was determined by the Chief Justice that on and from Monday such and such until further orders, Mr. Justice Bhagavati Prasad Banerjee would sit singly and take part hard and contempt matters. This determination was operative and effective on April 6, 1989. This is apparent even from the cause list for the day. On that day, therefore, the learned judge could have heard only part hard matters and contempt matters arising out of his own orders and none other. Para 27. We have looked at the original record of the writ petition out of which the present appeal arises and do not find any direction in the order sheet that the case was to be treated as part hard. It is therefore difficult to appreciate how the case could have been listed before the learned judge and how the impugned order modifying the interim order previously granted could have been passed by him on that day. Besides, the terms in which the interim relief was granted at the stage of the issue of rule in the present case have been quoted earlier. Liberty was thereafter reserved to the respondents in the writ petition to apply for vacating and or varying the interim order upon notice to the writ petitioner. The proper remedy for the party aggrieved by such interim order was to move an appropriate bench which was dealing with the said category of cases under the extant determination. Then paragraph 28. For the aforesaid reasons, the order under appeal without jurisdiction is and declared to be void and having no effect in the eye of law. Paragraph 28 is a conclusion, is void, or nullity. Last. Judgment of the Supreme Court judgment of the Supreme Court judgment. Which is it any stage 77 Supreme Court?
Yes.
Now, my lord, I am not troubling your lordship with 1998 volume 1 SCC page 1. Supreme Court elaborately giving direction as to what should be the determination, what the learned judge can assume jurisdiction, and Supreme Court has categorically stated it is the prerogative of the Chief Justice to give determination, and the prerogative of the Chief Justice to withdraw contempt matter, pattern matter, anything from any single judge. That the elaborate, my lord, paragraphs the Supreme Court said, the question of taking any matter by a judge, the honorable judge, is according to the determination, and the roster, he is the head of the roster by the honorable the Chief Justice. Therefore, this is not the determination enjoyed by the learned single judge, passing the order, extending the interim order, even on a reminder to his lordship that you have no determination on this day. This is a nullity. Now comes the moot question, my lord, the question of law, whether the 1977 Supreme Court.
You did
1977 Supreme Court, page 5, it says.
Did not tell us which paragraphs you are referring to of this Supreme Court judgment.
Supreme Court judgment, yes. This is paragraph 10, 59.1, 59.2, and 59.3. This, my lord, actually this elaborately the general conditions of the determination of the honorable
And may short leave matter has been called. May I just. I'll stay.
About 2 decades I have been there. I never did this. When the matter is being argued, I would never abandon a court. Whatever may be the fate in the other court. And that also a division bench. You want, it is so. I will not stop you, but there is a thing known as right and there is a thing known as author.
It is bind.
Maybe right.
It is bind.
No, should I read the paragraphs in detail? It's possibly not required because this is the celebrated judgment of the 3 honorable judges.
Yes.
Actually, this has arisen from a dispute in Rajasthan High Court when our honorable the Chief Justice Mukul Gopal Mukherjee was the Chief Justice. And the question was that his lordship a rule of contempt was issued against his lordship the Chief Justice by the coordinate judge. And that was taken to Supreme Court, and Supreme Court had come with the observations. This 1998 volume SCC page 1. Yes. And the details of the thing had to be given by the honorable judges, 3 honorable judges about the determination, questions, power to determine all these issues. Now, my lord, actually I was referring to, possibly your lordships will kindly allow me to place the judgment of the Supreme Court, whether the question of law can be taken at any stage, and also when an appeal is pending, the learned judge can extend the interim order, whether he assumes jurisdiction on that at all, this point also. When it was apprised to his lordship that appeal is pending, his lordship could have said, very well, pray for extension of the interim order from the division bench. Supreme Court has categorically stated when an appeal is pending, till an application for stay is heard. Not only this, no contempt proceeding can be allowed to continue till it is heard by the division bench, who are in the session of the matter and assuming jurisdiction to decide on the issue. This was also brought to his lordship notice that appeal is pending. Now, my lord, this is 1977 Supreme Court. 1977 Supreme Court. 1977 Supreme Court, page 5. This is also reported in and also reported in SCC 1976. ওটা আলাদা ওটা পরে দিচ্ছি 77 সুপ্রিম কোর্ট ওটা এসসিসি তে 76 এ আছে দেখো আমার ফাইলের মধ্যেই তো ছিল No, I'm sorry, just I'm taking 1 minute. This is the principle of law. Unless the other side is put into wonder or difficulty, a question of law can be taken at any stage. At any stage, appeal stage, before the coordinate bench, or any other proceedings. Appeal question of law. Now, my lord, comes the moot question. The question I do not know. Huh? No. These are contempt of courts, my lord, judgments that when an appeal is pending, no contempt, nothing will be heard. This is of the also 3 honorable judges judgment 1992 volume 4 SCC page 167.
Is any issue of contempt here?
No, contempt notice was given.
Contempt
notice for implementation of the unless single judge's order. We have given reply that since the releasing order has not been stayed, there is no contempt. They did not file application for contempt as such. This judgment, possibly your lordships are aware, I need not trouble your lordship, that when an appeal is pending, contempt or any other thing shall not be proceeded with.
77 Supreme Court.
No, 77 Supreme Court, page 5, AIR, deals with the right to take question of law at any stage.
And which judgment? Modern Foods?
No.
Modern food starts.
No, modern food is also blood. Modern food is 1995 supplementary 4 SCC, page 465. Yes, that also deals with this same issue. That when contempt matter is moved, an appeal is pending, whether it has to be proceeded with. This is the thing. These are the 2 judgments about the question when appeal is pending. Now comes the moot question whether my learned friend will take the point or not, whether an appeal lies.
You are not coming up against the order passed for issuance of notice in a contempt. Here
Notice?
the issue is only regarding the interim order. The issue of contempt is not here.
Yes.
Yes.
Interim order, whether in interim order.
So primarily whether he had the jurisdiction by virtue of not having a determination, and then sustainability of the order itself, the status of the status of the petitioner being that of a reputationist.
Reputationist as registered. Now, 2. Third is my lord, that whether the learned judge could have entertained the writ petition, or if he had been given the determination to give simpliciter direction for affidavit. But when he has been released, whether status quo ante can be given, it has not been done. Release order has not been stayed, but other orders have been stayed. This is virtually final relief at the interlocutory stage. And if my lords kindly find what is the observation of the learned judge, initially I was inclined to dispose of the writ petition by satisfying the order. But since I prayed for affidavit direction, and he was generous enough to give the direction.
We have not even seen the Honorable Single Judge order yet.
Yes, kindly see this. Page 14. The judge's order. Page 14, my lord, kindly come. Page 14. 14 কোথায় পাচ্ছি? Yes. 14, it starts 6 November 2025 order. His lordship has decided the issue on a Supreme Court judgment that is not relevant. That question simplicity relating to resignation, that is not relevant at all. And secondly, my lord, kindly come to the observation where the learned single judge has said, para 22 is the relevant observation. Court was contemplating to dispose of the writ petition finally, but on behalf of the respondents, opportunity to file affidavit in opposition is sought for. At the interlocutory stage, without giving direction for affidavit, in terms of the appellate side rules, his lordship was going to dispose of the writ petition. And then what his lordship did is to pass a mandatory order, finally granting final relief to the petitioner to join. It is not stated to join, but when he has released, this order is also not implementable.
Question of law can be stated.
Yes. No, seriously. আমারটাতে তো মার্ক করা আছে সব। This is কোথায় দাঁড়া আমার আমার এখানে আছে দেখো না আমার মার্ক করা আছে বাবা appointment until further arrest of the no until further arrest এখানে নেই হ্যাঁ আছে দেখেছি ঠিক আছে
Yes.
Milord, kindly come once in the list to page 72 of the writ petition.
Can.
The original appointment letter of the can, page 72.
72.
Yes. This has been written, Milord, actually to my client, All India Institute of Medical Science, to the registrar Uttorbongo Krishi Vishwavidyalaya, where the present writ petitioner was employed and he retains that post. That is subject appointment of Sri Subhendu Motilal, that the writ petitioner. Kindly come to clause 2. The appointment of Sri Subhendu Motilal will be on deputation basis with effect from the date she assumes charge of the post initially for a period not exceeding 3 years or until further orders. The learned judge has not decided the issue that whether we assume jurisdiction to terminate him, not repatriate him to the original post. His right under Article 16 or any other right is not affected by this decision.
Not exceeding
Therefore, this is a, my lord, he shall go by the appointment letter. Laden Singh judge has not decided that issue. Now comes the moot question, my lord, whether an interim order is applicable under the latest patent or under any provision of law. This is a judgment of 3 honorable judges of the Supreme Court, where the Supreme Court has decided that interim order in this nature is not only applicable under clause 15 of the latest patent, but exhaustively also on order 43 rule 1 of the Code of Civil Procedure. Order 43, my lord, this is clearly Supreme Court says not only under the latest patent, but also under order 43 rule 1 read with section 104 and 105 of the Code of Civil Procedure. The paragraphs are 26, 47, 62, 70 and 78. 26, 47, 62, 70 and 78, and also reference in para 21, 28, 33 and 62. Elaborate discussion as to whether latest patent or right under article, this actually Civil Procedure Code is applicable in our honorable court in view of rule 53 of the appellate side rules, that principle of Civil Procedure Code shall apply in writ proceeding.
That applies to every high court. In principle.
Our rule, I am saying.
In principle.
Yes.
The CPC does not apply, but the principle
shall apply. Therefore, this is a right. And when the learned judge has, by the order itself, has decided the order, writ petition lists whether appeal lies and whether there is a judgment under clause 15. Finally, my lord. Two, pending appeal, neither contempt nor this is the judgment I referred to, 1977, AIN 1977, Supreme Court, page 5. The question of law can be taken at any stage. This has a reference also in 1976, volume 2, SCC, page 152. There in paragraph 11, the 3 honorable judges clearly decided. That the question of law can be taken at any stage of the proceeding. Para 11, and reference to other citations, their losses came to the finding. Now, my lord, you lost his own judgment. Pending appeal শোনা যাবে না। আটটা দিন।
You don't want us to understand anything. You don't want me to understand anything. He will probably understand whatever you are saying.
Vernacular Bengali, yes. He was asking for the reference of 2 judgments, where even when appeal is pending.
Why the secrecy from me?
No, he cited. Give the citation. Modern food is one.
Yes.
There is some other judgment he says.
He did not cite it. He said there is another judgment.
He did not extend it.
Even modern food, he has not given the judgment.
Modern food, yes. Modern food, yes.
Modern food industries.
Yes. 1995 supplementary volume 4 SCC, page 465. আরেকটা দিয়ে আমি দিলাম যে para 6 modern food, directing all further proceedings in the contempt proceedings to be stayed. The Supreme Court observed that it would be appropriate for the High Court to take up and dispose of the application for stay without reference to the developments in the interregnum. It added that depending upon the outcome of the appellant's application for stay, the further question whether or not the reinstatement should be reversed would arise. This is the other judgment also, my lord, I need not trouble it. This is sufficiently, it covers everything. Now comes the moot question of my lord Mr. C. Madhuresh Prasad's judgment on the identical issue. আমার মার্ক করা আছে, ওকে দিয়ে দাও একটা কপি দাও, দেখি দাও আমার মার্ক করা আছে দেখো। My lord, I am just reading. Your lordships have been pleased to hold what is the right of a deputationist. What is the right of a deputationist? Yes, এখানে দেখো তো। This right, your lordships have been pleased to decide on this issue on the basis of two Supreme Court judgments referred to by the Government of India in para 19 onwards. May I read, Miller 19? In view of the findings recorded herein above, we find reliance placed by the petitioner on the decision in the case of such and such to be misplaced. He has specifically relied upon paragraph 25 of the judgment, which in our opinion is inapplicable to the facts and circumstances of the present case. No case is made out regarding the petitioner's repatriation being done in post-haste manner, so as to invite a presumption of the repatriation being tainted with malafide. We have noted above the manner in which the repatriation has been done by issuing a 3 months advance notice in accordance with the paragraph 9 of OM such and such. We have also taken note of the fact that the repatriation was with the approval of the competent authority, namely the Minister of Defence, such and such Government of India. The notice of repatriation and repatriation order are directing repatriation simpliciter without recording any finding prejudicial to the petitioner or which may in any way cast a stigma on the petitioner, we therefore find nor force in such submission. This is exactly our case. No stigma, nothing. Insofar as the other judgment, such and such, relied upon by the petitioner, we find that the same also has no application to the facts and circumstances of the present case. The petitioner has placed specific reliance on paragraph 12 of the said judgment, from bare reading of which it is obvious that the judgment concerns an appointment to a temporary post. It is in this context that the Apex Court observed that even an appointment for certain specified period gives the government servant so appointed a right to hold the post for the entire period of 10 years, which cannot be curtailed or put to an end during the period except by way of punishment, dismissal, or removal from service. The present case is not a case of 10-year appointment. We are considering a case where petitioner was sent on deputation. Now kindly come para 21. On the other hand, this is our submission. The respondent authorities have placed reliance on the case such and such, which has stated the basic principle underlying deputation in para 6 of the judgment in the following terms. The basic principle underlying deputation itself is that the person concerned can always and at any time be repatriated to his parent department to serve in his substantive position therein at the instance of either of the departments, and there is no vested right in such a person to continue for long or deportation or get absorbed in the department to which he had gone on deputation. Then para 22. In other judgment relied upon by the respondent is judgment of the Apex Court in such and such. This judgment also lays down that the employee being on deputation could be repatriated to their parent cadre at any time, and that they do not get any right to be absorbed on the deputation post. This is your lordship's finding. Clear finding, identical issue, deputation, and he has been repatriated to his original department at North Bengal University as assistant registrar. He has not been imprisoned, not a single right under the constitution, either fundamental rights or legal rights. Nothing except that he has made out a feeble case of the withdrawal of resignation by him, which gives him substantive right to continue without looking into the fact that the appointment letter contains right to take any decision within 3 years or until further orders. Therefore, these are the issues the learned judge did not consider. The learned judge on his finding has come to a conclusion almost giving final relief in the writ petition, which is not permissible at the interlocutory stage. The learned judge was determined to dispose of the writ petition by setting aside the order. Since I prayed for that, his lordship has given that determination. And when his lordship was brought to the notice of this, his lordship as not having the determination, his lordship ought to have decided that issue. Without deciding that, his lordship extended the interim order till 31st March. Therefore, these are all illegalities, my lord, which are to be interfered with by granting a stay to us. If your lordships want to hear the appeal, we have no objection, but this order has to be stayed. We are facing tremendous difficulties in a national institute like All India Institute of Medical Science by this particular person after he has joined his duty after this interim order.
But if he has been released, how is creating any problem?
He has been allowed to join on this contempt notice, but his salary, he has made an application before the learned single judge during the pendency of the appeal that he release my salary. Not giving the attendance sheet, nothing. This is creating so much of problem. This is an educational institution of national importance. I need not draw your lordship's attention to until list 1, 7th schedule of entry 63, 64, and 65. Whether in an institute of national importance this can be allowed.
No, but you showed us the relieving order of 31/10/25. After that, what happened?
31
he has been allowed to rejoin.
Only order initially which was passed, he has been allowed to join. He was not assigned any duty. He was not being paid except some period. Now he is claiming salary by making an application before the learned signature since December. Therefore, if the order is not sustainable at all, the order is nullity passed by the learned signature on several counts, whether he has accrued or acquired any indefeasible right to continue in the post or enjoy the benefit of the interim order.
See, basically an interim order is passed on satisfaction of three issues: a strong prima facie case and a balance of convenience and interest of justice. So, insofar as the interim order is concerned, these are the only three things which were required.
That apart, my lord, kindly allow me to place.
Prior to that, you have raised an issue of jurisdiction before lack of determination. So that is another.
And pendency of the appeal.
And pendency of the appeal.
That apart, my lord, kindly allow me to submit also this. That the first codified law regarding grant of injunction was incorporated in the Specific Relief Act. The Specific Relief Act has three categories. First, when court can grant injunction, when court can refuse injunction, and whether it is discretion. Now, Section 36 of the Specific Relief Act says it is purely discretion. And 41 says that if there is an alternative remedy, no injunction can be granted. If conduct is bad, the Supreme Court has now said, even if there is prima facie case, balance of convenience, inconvenience, sense of justice, conduct is bad, he has resigned on his own, not by force. And conveniently, when we are going to repatriate him.
Where is that resignation letter?
Yes, page
86.
Page 86.
And where is the order passed by you on that resignation letter?
Yes, kindly come to page 86, annexure P7 of the writ petition. With due respect and humble submission, I would like to resign from the post of registrar. In this regard, you are requested to consider the notice period as applicable with 1st August 2025, as this is a notice for serving the contract, so on no reason is now referred to. Kindly release accordingly. He himself has prayed for release.
This resignation is under which provision?
This is resignation is on his own, on the basis of a contract. There is no specific provision that he can resign.
See,
he is
every service rule or retirement rule has a provision for resignation.
Yes, that is in respect of a permanent employee.
Therefore we are saying.
Yes, he has annexed a document. I am showing to you. Yes, he has annexed a document in respect of the permanent employee status of a notification that learned judge has also relied upon the court. Yes, page 96. Page 96. Page 96. Withdrawal of resignation of central government servants. This does not stipulate about the deputation employees.
Sir, these are resignations from service, not from a post.
Yes.
The resignation can be from a service, not from a post where he is posted.
Yes.
He is saying, I resign from the post of registrar. He is saying, I am resigning from the post of registrar.
Yes.
Where is the provision enabling such a resignation? One has a right to resign, which will entail forfeiture of all past service. Or one may have a right to take a voluntary retirement if the rule so provides. Any particular post to which a government employee has been posted, can he resign from that post and still stay in service? Is it possible?
That is not possible, and that is, I don't find in the contract also there is so many words written. That apart, my lord, the resignation apart, I have categorically argued before your lordships. Apart from the issue of resignation, if we forget
No,
about it.
because the honorable single judge, whatever he has decided is because the resignation was submitted and you have given an assurance on the resignation.
No, we have not given any assurance.
That is
It
what
was
we
delayed.
find. That is what we find from the.
That is wrong recording.
We have not seen those 2-3 documents which have been referred to.
Yes.
There is a 24th October document, there is a 27th October
Yes.
document, and there is a document of August. There are 3 documents
Yes.
which are said to be issued by you. We have not seen those documents. But he has been, perhaps he has taken into consideration the fact that you were already entertaining his resignation, and then you have made a volte-face and issued an order like this.
No,
This is what is.
We actually, during the pendency of the question of withdrawal of resignation or releasing him, there was all an order that we are taking steps for repatriation. It was communicated to him. He has simply taken a plea.
You have not responded to this resignation of first.
Immediately, I have not responded. That's true. Immediately, I have not responded.
No, any response from your side on this resignation?
No, thereafter, 4th October 2025 order.
Correct. That is
in partial modification of the office order number such and such, the undersigned is directed to convey that the repatriation of Sri Subhendu Motilal, Registrar, on deputation to his parent organization is on his own request. The remaining terms and conditions of said office order dated 8th August 25 remain unchanged. The fact of repatriation was communicated to him.
The resignation on 1st of August, we replied on 8th of August, and thereafter 8th August চিঠিটা আছে at page 87.
Page 87, kindly come.
1st August he resigned.
This is of 8th August 25, 1st August he resigned.
It is not open to comments and from can resign from service. Then it is very good if I'm transferred somewhere outside and then what happens? So you have to accept it. It cannot be. Cannot do.
So all these orders are on repatriation. There is no direct order from your side on his resignation.
No, but kindly appreciate one.
Is there any communication from your side, some email which has been referred to?
We have subsequently communicated to him that your resignation has been accepted.
Please show where is that. We would like
before that kindly come once in the list to page 87.
We are looking at page 87.
Page 87. 1st August is his resignation.
Yes.
Second is 8th August. The approval of the competent authority is conveyed to us premature repatriation of Sri Subhendu Motilal, Registrar, on deputation with effect from 31st August 2025, namely after completion of 3 months requisite notice period. A formal order of relieving the officer from the duties of the institute will be issued in due course after completion of codal formalities. So we have time and again communicated to him that the repatriation is being considered, that it is with 3 months notice. There are 3 aspects. Whether 3 months notice is required, that we have complied with. Whether until further orders before 3 years, 3 years we can terminate him or relieve him.
You cannot, yes, you can repatriate him.
Repatriate,
you
not
cannot
terminate.
You cannot terminate.
Yes. That too is within our power. 2. 3 is the given situation is of resignation. Had it been a case that he is alleging that he is being forced to resign, it could have been different. Once resignation is made, his right of the post, his continuing or service ceases. And acceptance is a formality subsequently. It is not the case that a resignation has not been accepted subsequently. Kindly come to the acceptance of resignation. Yes, again another letter was written to him by email with reference to this honorable judge, single judge has relied with page 103. With reference to your query, it is informed that your request for resignation. With reference to your query, it is informed that your request for resignation withdrawal is presently under process. The decision of the competent authority will be communicated to you shortly. Then comes the question of acceptance of the resignation. Kotha.
27th of 109.
109.
27th has been stated by the
This has been stated by the Honorable Single Judge. The request letter dated such and such, page 109, submitted by Subhendu Motilal, registrar on deputation for withdrawal of his resignation repartition has been duly considered. However, the request has not been acceded to by the competent authority. Therefore, Sri Subhendu Motilal, registrar on deputation, will be relieved of his duties with effect on 31st October 2025 and to rejoin his parent institute, that is Uttar Bongo Krishi Vishwavidyalaya, Coach Bihar. Accordingly, Sri Subhendu Motilal, registrar, is requested to submit his no dues from concerned sections and such and such. Therefore, there are three stages, and it is AIMS authority, administrative officer. He has referred the issue to the competent authority. On their approval, the resignation is accepted.
Not accepted.
Yes, page 109.
The withdrawal has not been acceded to.
It has not been acceded.
Withdrawal has not been acceded to does not mean his resignation has been rejected.
Yes.
Means his resignation has been accepted.
Yes.
No, my lord, if you kindly allow me to please.
Please read
Yes.
again.
Resignation, then
Please read.
He has given a resignation, he has withdrawn it.
Correct. Now
comes the final order.
Yes.
The request letter dated 20th September 2025 submitted by Sri Subhendu Motilal, the read petitioner,
For
registrar on deputation for withdrawal
of
his resignation.
Yes.
Repartition has been duly considered. However, the request has not been
So
acceded.
withdrawal has not been acceded to.
Yes, you have not accepted his request.
You have not accepted his request for withdrawing the resignation.
True.
Not
But if
that you have not
subsequently,
accepted his
with
resignation.
great respect, I submit, if subsequently on this letter, we relieve him, what is the meaning on interpretation, conjoint reading of the interpretation?
Oh, we are at a more preliminary stage. Is it open to an employee to give a resignation from a post,
Yes,
or a resignation can be from service?
yes. But it is kindly appreciated, it is not a regular service as contemplated under service jurisprudence.
Correct. Therefore,
it is in your lordship's own judgment, this is right of an employee on deputation is very limited.
Correct.
He has no right to remain in that post.
We are wondering what decision you are taking on his resignation.
124?
relieved.
124?
Yes.
Page 124. With reference to, this is 31st, this has not been stated. With reference to office order dated such and such, and subsequent office order 27th October 25,
this.
Sri Subhendu Motilal is hereby relieved from the post of registrar.
We have seen that. We have seen that.
Post of registrar. Therefore, even merely on merit, I do not submit anything. Whether he is entitled to sustain the interim order in view of the lack of determination, which is a nullity. Therefore, it has to be stayed in any event by the appeal court. And then, the question of continuation, merit, all these things, I am, for abundant caution, I am arguing on merit. But
Right.
the question is whether the learned judge had any determination, and that too, it was brought to his lordship notice, pendency of the appeal and determination. His lordship has seen this. The order, his lordship recorded, but extended the interim order. This is a nullity, this is another illegal order. First, therefore, it has to be stayed on this court alone. Then your lordship, if your lordship want to hear the appeal, fix a date.
No, we have heard so many things. Now we'll hear them.
Judges can do second order took place with 29 January.
My lord, may I just bring to your possible your lordships have seen the extension order at 29th January
At
can 2, this has been annexed. 29 January 26 order extending the interim order. Page 10. Matter has come in the list for extension of interim order, which was passed on 6 November 25. As the interim order is expiring on 30th January 26. Such and such on behalf of the respondent 1 to 3 and has opposed the prayer for extension of interim order on the count that this court has no determination since this matter relates to higher education. However, no affidavit in opposition has been filed as yet in terms of the order dated 6 November 2025, and at the time of hearing of the matter on 6 November 25, the issue of determination was not raised. Court is also informed that an intra-court appeal is preferred against the order dated 6 November 25, which is running in the list of the Honorable Division Bench and will be taken up soon. Interim order pass is extended. No reason, nothing.
Yes.
No reason, nothing. It's unfortunate.
We take notice of this.
Yes.
The petitioner's presence, even virtually is warranted because I'll be making some submissions on his instructions, which we have not received in writing. Why? What prompted him to put in his papers, first? He was, there are certain communications in these appeal papers which would show that certain, disputes were there regarding his, entitlements which were being deprived to him, by Ames Kollan. And consequently, he was working as the deputy registrar in Uttarbanga Krishi Vishwavidyalaya. This was on a deputation, appointment on deputation. This is not a transfer on deputation. This was an appointment. He was appointed apropos a selection process, apropos an advertisement published in that regard, advertising various posts which included the post of registrar. Now, owing to this problem, he had initially, decided to put in his papers. There are communications from his principal employer addressed to Ames, clearly, indicating, that if this is clarified, then there is no problem because, this salary or whatever, the entitlements will not percolate to him. It will go straight to his principal employer, which was being denied. Even today, it is being denied. Now, since this appeal and there is a dispute, regarding his entitlement to the salary for the period of December, January. December has been paid. January is yet to be paid. They are raising various issues. We have
Those issues are not in the present writ petition.
Now,
present writ petition is confined to the relieving of the
what we are
deputation, nothing else.
Since my lord is insisting over the matter,
Yes.
He has instructed me to make this submission.
See, we will confine to the records. We will not allow you to make any submission on a verbal instruction like this. This we don't appreciate.
Yes,
this we don't appreciate.
Your lordship is correct.
Nothing out of the hat like this in the midst of a proceeding.
If your lordship so desire, we'll file an affidavit.
We don't desire anything.
No, kindly hear what I am saying.
Yes. Don't say such things that I will make submission based on instructions regarding an issue of fact. Neither they know it, nor we know it, nor it is part of the record, and we should consider it in a writ in the writ proceeding. Then don't say on instruction. You can confine to the records.
Instruction I am making the submission. Then
confine to the records.
Agreeable, to put in, to go to my principal employer. I am agreeable to do that.
That is not our concern. You may be very good for you. Then go.
That much protection I am seeking from your lordship, which is an issue here.
What protection?
Protection is, this LSPC, the last protection certificate, this has to percolate. The leave, salary, and other entitlements has to go, which is a part of the records. Kindly seize this document.
See, now, if you are genuinely submitting so on instruction,
yes,
that was not the issue before the Honorable Single Judge.
That was not the issue.
Still, if that is an issue pinching you, you can approach them for whatever is due, and whatever is admissible, they will give you. You go home. You go to your place.
They are not, adhering.
You can't make it a condition precedent to. You can say that I am going, but you resolve these things within so much time. They will have to do it, and they cannot deny. we can record an
Then may
order
I-
that
may-
they will deal with
may
this
I
thing and
most-
make a final
before
order on that claim within 15 days or whatever.
before adverting onto the other aspect, my lord, may I just show your lordship two documents from the papers here?
If you are having such a genuine approach, why should we go into the documents? If you are having such a genuine approach and a genuine grievance which you have expressed, we will see if they can deny to look into it.
May I just show your lordship the document?
What document?
Kindly. Now, please come to page, my lord. Now, it will be page 83.
Yes.
My lord, calculation of leave salary and pension contribution in respect of, my lord, the writ petitioner, assistant registrar. In response to the subject cited above, the calculation sheet of leave salary and pension contribution of Sri such and such in purview of memo dated 21/2/18 is attached. It is pertinent to state that the stated calculation sheet is duly vetted by the competent authority of the university. My lord, that is page 50, the next page, page 84. My lord, calculation of leave salary and pension contribution. My lord, this has not come to him, or it has not gone there.
Again, we are asking you, if this is all that is troubling you, then you please say so.
My lord, my instruction is that is the principal issue today which is troubling me, because my lord, I
Not
want-
today.
my lord,
Bring the issue to an end.
My lord, we want to, my lord, he wants not to put the issue to an end because he wants to live in peace rather than, my lord, in this rigmarole.
Yes, and they want peace for the institution. So therefore, we don't think that they will deny.
My lord, then, my lord, just, my lord, a little, my lord, ahead of the papers, my lord, please stop. Kindly.
We are not interested what is the details of the dues. You may submit a dues of whatever X amount. They may find X plus something. They may find X minus something. We don't know. That is for them to consider. We are not to look into this. So if that is your only concern, then if you are willing to give the issue a quietus, then we'll ask them to consider the thing and dispose it off by reasoned order. You pursue the issue. You go and join your service rather than indulging in this pointless litigation. Neither you are here nor you are there. What is the fun? We don't know. It's a litigation for the sake of litigation.
My lord, that is, my lord, if your lordship is rising, my lord, we'll come back at.
You ask him. You ask him.
Remain present.
No. If he wants, he's more than welcome.
Ask him, my lord.
You ask him that he wants to bring the issue to a quietus, then we can think of passing an order.
Lordship keeps it, my lord.
After recess or tomorrow if you want to come back.
She is here, my lord.
So we are just accepting it. He is filing it with, he has given you a copy. You give.
Grateful.
Yeah.
They are filed on 18. And when you cause the our difference of argument, then they are filing.
No. So therefore, what is wrong with that? We just wanted to know that it was served on you. All right. Take it. We'll see.
My lord, we have, my lord, taken the liberty, my lord, to annex all the judgments we have relied on, and the chart of the whole thing is in the first page.
We'll see tomorrow. We just wanted to know that it was served. Tomorrow, when it comes up, we'll see. Okay. Tomorrow it is to be listed.
Yeah. Gratefully, Lordship.
अरे ये सब यहाँ क्यों छोड़ रहे हैं? You have left all this from the last case. Why you have left it here?
Lord, in this matter, Lord, paper book
That
could not be
last-
placed.
This one. This also. Yes, what is the FMA?
Lord, last occasion, Lord, as the paper book could not be found, Lord, the Lordship directed to, it was in code number 13, and paper books have not come. Now it has been placed before your Lordship. What happened, Lord, the paper book, the appeal number has been wrongly typed. It should be 1555. Your Lordship kindly allow my learned junior to correct it, and Lord, your Lordship directed to serve notice. Paper book has been served. Notice with the clarification that this number is correct number giving served. One of the respondents have received. Two others, Lord, postal return has not yet come. Your Lordship kindly fix the matter next Tuesday, Thursday, and in the meantime, Lord, allow my learned friend to correct the number.
So who has not been served? Which respondents?
Except State of West Bengal, the University Authority has not yet come. State of West Bengal has received.
So Union of India, it cannot be, it has to be served in the department.
Yes.
There is, as per submission.
My lord, I am appellant for item number 10 and 12. My counsel is coming soon. Just 5 minutes. Yes.
We were asked to wait for 5 minutes that you are coming.
I have told him.
What kind of prayer you are making, sir? Such a senior person.
I'm sorry.
That he is coming for 5 minutes, you wait or you are done.
We are attending our
Anything. Yes.
We are tendering our apology, my lord.
Well, I'm taking for a 1 week adjustment. Yes, what is it?
My lord, this is a, my lord, there are two appeals, my lord. 10 and 12, my lord, is my appeal. My lord, I'm
11 and 12.
10 and 12.
But there appears to be many cases.
Yes, my lord, they have been tagged, my lord, all the appeals for deciding the, my lord, question of maintainability. My lord, kindly don't take me amiss, my lord. This matter.
You are appearing in 11 and 12.
10 and 12, my lord.
10 and 12.
Yes. The appellant is the appellant is my lord Kumar Mukhopadhyay. My lord, kindly don't take me amiss, my lord. This matter has been extensively heard by a division bench presided over by Justice Sujoy Paul. And my lord, the written notes of argument has also already been submitted. This matter has not been, my lord, recorded as one of my lord's partner matters. But if your lordship sees the orders, my lord, plus one that is of 20th August and my lord's 28th of August.
Mr. So-and-so, learned advocate.
Eleven, 13, 14, 15, 16.
11 to 17. It is 10 to 17.
16.
16. 10 to 16. Yes.
11 to 16 except 12.
Yes.
Then 17.
On last occasion, my lord, on the 5th of January 2026, my lord direct, the issue is pending before the Supreme Court, my lord. So my lord directed asked the respondent to ask for the present status of the case. Well, they are not available, but from the advocate and record of our, my lord, I have received this, my lord. I am asking them, two copies are there.
So it is pending, that means.
Yes, my lord, it is pending.
One communication.
My lord, Mr. Somabujinder is appearing for the petitioner, but he is on his legs, my lord. Pursuant to the last date order dated last date, my lord, may I submit the compilation of the judgments?
Give us.
The bill arises out of which order? It arises out of which order? Which page? Which order?
Page 71 is the order number page 7 2014. Page 71.
This appeal arises out of which order?
Not page 161.
And where is the recognition?
At page 27.
And that order which allowed you to resume.
It's at page 71.
Page 71.
Yes.
Not my very short point is when no punishment has been imposed, not whether I am entitled to full pay during the period of this suspension.
8714 order, you did not put to challenge, you have put it into effect. You have taken benefits which according to them flow as a consequence of the 87 order.
87 got modified on
19.2.
31st of October 2014.
30th, not 31st, 30th October.
30th October.
Where
Page
is that?
70. That's page 74.
74. That is a page.
Is
It is not modification, it is actually giving effect to the order.
There is partial modification of this office order. Leave is
Yes,
hereby
but that is the
sanctioned.
consequence of the order, which is
Maybe, but
87 order. 87 says that period from 5/10/2005 till the date of the court's order is to be treated as a period under deemed suspension and may be regularized by granting leave due. So they have regularized it by granting
not,
the leave due.
all these orders not came to be challenged. 3 orders came to be challenged.
This and 15, 10, 14.
Yes.
30, 10, 14.
30, 10, 14 and 19th February 15.
No, this is the fixation order.
Fixation order, no doubt.
This is a consequence. Actually, the base order is of 8/7.
July, yes, 14.
These two orders are as a consequence of the base order. And you have not challenged these orders.
8 July is under challenge.
Just read the prayer.
My lord.
How such a prayer can be made. Direct them to resign and withdraw and cancel. You are not assailing the order. You are seeking a direction upon the respondent that they should withdraw.
Lord,
Please read the prayer what you have.
yes, Lord Mandamus to certify and transmit the records of the case, including the orders, so that just conscionable justice may be administered by quashing the same.
But the direction is which you have sought is that they may be directed to resign, withdraw, recall.
But the conventional prayer in Mandamus is not a direction upon the authorities to do in a particular manner. That's not the conventional method of praying before a court.
The Mandamus will issue it's a case for certiorari.
But certiorari normally not once again that not it applies in quasi judicial proceedings, not the 64 Supreme Court judgment.
The case for certiorari. They will certify the order and it will be produced before.
But certiorari normally not, please recollect Syed Yaqub's case, not it's normally applicable in cases of quasi judicial functions.
It's all right, but an order in a departmental proceeding, an inquiry officer, what kind of a role does he perform?
But he performs, no doubt, but not here there is no disciplinary action taken.
No, this is an action pursuant to the disciplinary authority's decision.
Which has been
on the inquiry report.
Which has been foregone. But there is no disciplinary action which has taken, which has been carried to its logical end.
Submission. The facts are that proceeding was initiated, a particular decision taken. The court did not agree with that decision, remitted the matter to the disciplinary authority. The inquiry report was not interfered with. So the inquiry report and the inquiry officer's report and finding is there. On such a report, the disciplinary authority this time says, forget it, you give a fresh caste certificate. On these terms, we allow you to resume.
This is under challenge.
So there is no order cancelling the departmental proceeding.
But the conduct as revealed from the respondent authorities' action is they have decided not to carry forward any further with the inquiry proceeding.
Caste certificate.
Yes.
Then?
But I said that very well. Let it be given a burial. I joined. I have resumed my duties.
That is it. Now you can blow hot and cold at the same time.
That was prior.
The benefit of the order and give a caste certificate.
Please come to the date. The date was 2nd of April 2014 when I produced it. April 2014.
That is not relevant.
No, that's there at page
the point is
68.
If you are agreed an order of 8/7/14, should I put it to challenge? You have complied with the order.
No, the direction to issue certificate, a fresh certificate was
8/7/14.
No, 2nd April 2014, page 68.
So that you have not challenged.
No, I have substantiated my claim.
So that you have not challenged.
So
therefore, there is an admission that the earlier caste certificate is
no. Please come to 2nd April language.
Yes.
In consideration of the submissions made by you before the general manager, you are hereby directed to produce a fresh caste certificate from the appropriate authority to substantiate your claim.
Otherwise, your claim will not be substantiated.
So they were satisfied with the claim that I substantiated before the authorities.
They told you that it can only be substantiated by a fresh caste certificate. You were to challenge this order if it was not your liking. That why should I produce a fresh caste certificate? I have already produced a caste certificate which is valid. So this order you don't challenge and you substantiate your claim by submitting a fresh caste certificate. What is the inference? The earlier caste certificate was not in order.
Today, we probably, two things may emanate from this. One, No authority, not this in effect amounts to a penalty. Insofar as the petitioner, yes. Now, can there be an unprescribed penalty?
Sir, how they have allowed you to submit a fresh caste certificate, that is itself.
It's for the disciplinary authority to take an action. They decided not to proceed
in
any further.
recruitment process, a public employment, whether they can do this. So they have been kind to you.
But somebody might have not given some allegation somewhere else.
Then they would not have asked for a fresh caste.
But they have asked for. But I have complied with the direction.
And you have accepted that you are required to do this to substantiate your claim.
But thus far admitted position. Now, what is the consequence of they are requiring me to produce a fresh caste certificate and me furnishing a fresh caste certificate? Not with no logical deduction or inference arrived at.
17, 12, 13 memo, where is that?
17, 12, 13.
Yes.
2003.
Report. 2003
probably.
No, 17, 12, 2013. Memo number 1965/G. It is referred to in this 2414 order itself.
That's misprint. That's at page 115. It's probably 17 December 2003.
115.
My lord.
My God. Directly connected to this finding that it's a manufactured caste
certificate. It appears to have been done so, but not your lordship has.
What appears to, they are referring to this letter.
Not your
the issuing authority says there is no such record of issuance of this certificate.
Not
a manufactured document. To counter this, you give a fresh,
Not after 1995.
Acceptance.
Not after 1995, your lordships have laid down not how it has to be done.
Sir, we are saying you are a beneficiary.
So not
you are a beneficiary of what is going on.
Now the question is to what extent? Not having decided not to proceed further with
got the employment. That way they have somehow accommodated you as it appears. We don't know how it has been done. But anyway, it is not before us. We don't want to embark on that. Now, having obtained such a benefit, can you avoid the consequences?
It's not consequence of that's what I want. Today, my lord, if I had procured a certificate in some other manner, or I was not a reserved category candidate at all.
Open to argument, sir.
That's right. Not,
by you.
Not that has come to a rest at the stage of inquiry. That's all.
It has come to a rest that it is a manufactured document and only you could substantiate your claim by submitting a fresh certificate. There is nothing left to say on that. This stands concluded by the facts as they are. Because they refer to that letter where it was declared a manufactured document by the issuing authority itself. And they said the only way you can counter is by giving a fresh. You could have said, no, why should I counter? It is a proper certificate. You had the option at that stage.
My lord, while referring to page 115, this is not a exercise undertaken in terms of not the regulations or not the law, which your lordships can very easily find out from the face of the records. But after 1995, the position has entirely changed. But it's a communication between two authorities, be that as it may. But I am not resurrecting, I cannot resurrect this issue now. Today, the question is after what happened after an inquiry report.
The findings of the inquiry officer were never disturbed.
No punishment imposed.
No, we will look at it slightly different. That a lenient view taken to give it a quietus because it has been lingering for so long. With certain benefit, they have allowed you to join on the basis of a fresh caste certificate. This transaction is to be taken as a whole or parts of it are severable. That is the only issue.
But the inquiry officer held me to be partly, the charges to be partly proved. There was a disagreement note. So not from the stage of disagreement, it's not there. It's a part proving of the charges. Now,
so let us see what is your submission.
Today, the authorities are bound by their own regulations.
Yes.
But your lordships are probably today called for to decide on the validity or not the action or interpretation of regulation 66 read with the provisions ensuing thereafter.
What is the regulation?
So that's how suspension has to be dealt with.
I have a copy with me, Lord, under regulation 66. 64 has been. This is the relevant portion of the ACL draft. 66 4 has been taken.
The appointing authority or any authority to which it is subordinate or the disciplinary authority or any other authority empowered in that behalf by the board by general or special order may place an employee under suspension.
Yes, which we have seen 66. What is it that you want to point out?
So that's all not where how the period of suspension can be treated. I'm not, although not very directly connected, but not if your lordships will kindly come to 8A and B. When the suspension of an employee is held to be unjustified or not wholly justified, or when an employee has been dismissed or suspended is reinstated, the disciplinary appellate or reviewing authority, as the case may be, whose decision shall be final, may grant to him for the period of his absence from duty, if he is honorably acquitted, the full pay and allowances other than conveyance allowance to which he would have been entitled if he had not been dismissed or suspended, less the subsistence grant. If otherwise, such that is one who has not been acquitted, such proportion of pay and allowances other than conveyance allowances as the disciplinary appellate or the reviewing authority may prescribe. In a case falling under clause A, the period of absence from duty will be treated as a period spent on duty. In a case falling under clause B, it will not be treated as a period spent on duty unless the disciplinary appellate or reviewing authority, as the case may be, whose decision shall be final, so directs. So, note 1, 8A deals with a case where there is acquittal, honorable acquittal, and B deals with a case where he has not been acquitted.
He deals with otherwise.
Otherwise.
Does not say not acquitted.
Right. Not
It says otherwise.
Not
otherwise will include a case as has been
say acquittal but not honorable acquittal. It could also be.
Cannot. Acquittal is the acquittal. Honorably acquitted means what?
But of course not. That coinage is not there in the erstwhile CRPC. No, that is as was explained by a Supreme Court in 2015.
No, here they are talking about service rules.
Right.
This is probably not an acquittal in the trial.
It could be because
although the expression should have been exoneration in a proceeding
yes,
of acquittal.
Because not there is a reference to deemed suspension.
Well, it could be. Could be in the case of a criminal trial also. That if a suspension occurring on account of a criminal proceeding, we don't know. During pendency of a criminal proceeding also there is a suspension.
Deemed suspension.
No, but normally that is deemed suspension at the time of arrest. Then it is there is a review of the decision whether to take him back, allow him to work or not.
But the power to suspend not includes, not encompasses everything.
Yes.
So not that's
it is obviously not under 8A.
Yes, it's not under 8A.
It cannot be under 8A.
Now not 8B permits a period to be treated not spent on duty in the event it is otherwise than A.
Not only that.
Please come to.
It will not be treated as a period of duty unless, as the case may be, the disciplinary authority directs.
Yes,
that is another discretion.
Yes, please read.
Not only
no.
one. Yes.
Not, B will kick in the absence of A.
Correct.
So
both cannot exist parallelly. That we are agreeing with you.
Not even if B kicks in, the disciplinary authority has the discretion to give him to treat this period as spent on duty, otherwise also.
So therefore, he has held a part of it to be spent on duty.
Now, not this power to treat him as spent on duty under B will only arise if A is not in existence.
Correct.
So, not I submit that my case falls under A.
How it can be?
Not because the authorities have not taken any. No, please come to 54 now.
There is no
not our disciplinary action initiated without a conclusion.
A just now we have, when we were examining A, it appears to be applicable to a case where there is a suspension arising out of a criminal proceeding. Therefore, it starts if he is honorably acquitted, because an honorable acquittal in normal parlance is only in a criminal trial.
Not normally, but not reading the entirety of the rules. Now, this could also be not in a disciplinary proceeding.
Even if that be so, where is the acquittal in the disciplinary proceeding?
There is no. There is a what was the stage?
Forget about honorable. Where is the acquittal?
There was a stage of disagreement. At that stage, the employer decided not to proceed any further.
No. That is your interpretation.
But the inquiry report is otherwise.
They decided not to proceed further. They decided to let you off easily. They said there is a report from the certificate issuing authority that you have submitted a manufactured certificate. Now you can overcome this by giving a fresh certificate. You accepted that offer. That yes, I am giving a fresh certificate. Now having crossed the threshold, you say the consequences I will not tolerate. Is it severable? Therefore, we asked. It has to be taken as a whole from 2/4 up till this 30/10 order. These 4 orders, they are not severable. They are in a chain.
This chain of events, which has resulted in reinstatement with the treatment meted out to me that this should be treated as period not spent on duty with regularization of the absence. Whether this can be imposed in view of the existing regulations which bind the corporation.
So therefore, we ask you which regulation comes in the way of issuance or exercise of such discretion by the disciplinary authority? Which provision comes in the way of exercise of such discretion?
The general principle, not an authority is bound by the regulations, not by the standards of.
So where is the provision which comes in the way of exercise of such discretion? As has been done in your case.
There was an initiation of disciplinary action.
Yes.
It ends with imposition or acquittal.
Correct.
Now, the penalties which can be imposed are in Regulation 58.
Yes.
None of these action or the penalties
Let
has
us
been.
See, where is 58?
Page 54. I'm sorry, Rule 50, Regulation 54.
Rule Regulation 54. It is part of the paper book.
Copy that.
Please give us also so that we can read it. So fragile, we are scared to take it. We don't want to destroy it.
But there is a second copy.
Thank you. You have a copy with you?
No, I have it.
Yes.
Notwithstanding anything contained in any other regulation and without prejudice to such action to which an employee may become liable, under any other regulation or law for the time being in force, the following penalties may be imposed on any employee of the corporation. It segregates minor penalties and major penalties. But these are the penalties which the authority can impose.
So you are saying his discretion is circumscribed by the provisions contained in Rule 54.
And there can be no unprescribed penalty imposed in a roundabout way.
Yes. Then we would need a copy of this.
My lord, we will hand over. Regulation. orders. They can do it. They said that this is the punishment, this can punishment exhausted.
Yes.
Number, so in effect, this amounts to an imposition.
This is an exhaustive list of penalties.
But there can be no unprescribed penalty. That's not the common jurisprudence. Now, although not very necessary to cite judgments for their purpose, but may I just draw your lordship's kind attention to one particular paragraph from a pronouncement of the Honorable Supreme Court in 2012, 5 SCC 242. That it is out. Lordships may straightway come to running page 55 of the compilation. It's paragraph 15 of 2012, 5 SCC 242.
Paragraph 12.
Paragraph 15 at page 55.
Yes. So your submission is his discretion is circumscribed by the penalties specified in regulation 54, nothing less, nothing more.
Not, if the disciplinary proceeding has not resulted in the conclusion of a penalty being imposed on a finding of guilt, but there was a stage of disagreement. At that stage, it went to the authorities. Therefore, not I should be entitled to all the benefits. And not here, it's a question of application of no fault theory for the purpose of arrear wages.
That is where we are unable to appreciate what you are saying. The question of no fault.
But I cite
you have accepted the fault. That will not make it a case of no fault.
But I cite not as a precedent for the ratio, but only as an example. Please come to 2012 13 SCC page 94, being running page number 34.
Yes.
But in this case, it is a matter of paragraph 51. In this case, it is a matter of record that upon exoneration in the departmental inquiry, the petitioner was reinstated in service. No punishment was inflicted on him at all. However, during the pendency of the criminal trial, as also the departmental proceedings, he was not considered for promotion, so and so. Please skip over the rest of the paragraph and come to the next one. We therefore partly allow the writ petition. We reject the submissions of Mr. So and so that the suspension of the petitioner was rendered wholly unjustified upon acquittal by the trial court. We also reject the submissions of Mr. So and so that the suspension of the petitioner was wholly unjustified during the pendency of the appeal before the High Court. We, however, hold that the continued suspension of the petitioner during the pendency of the departmental proceedings was wholly unjustified. The petitioner is therefore held entitled to full pay and allowances from the so and so, that is the date of the judgment rendered by the Delhi High Court onwards. We further hold that the petitioner was entitled to be considered for promotion notionally from the date on when an officer junior to him was promoted.
The essential fact in this judgment is upon exoneration.
Yes, but of course, not by only by way of an example. Not I don't say that not it's a precedent or not the ratio binds this case. But not the question is not the hands of the authorities are circumscribed by these regulations which are statutory.
That you have made clear. Regulation 54 you have relied upon.
So the
now whether regulation 54 is being invoked or 66(8)(b) is being invoked, having regard to the nature of order passed on 2nd April, that is a thing
that is
to
the
be
thing to be
considered. Yes.
My case is this, my lord, you have to kindly see. Page 74, the punishment order is at 8/7/2014.
Huh?
Page 71. The order, that page 74.
It's in library, or perhaps not. Just to Xerox to get it.
Page 71. Order is at 8/7/2014, to which you all these things has been happening. It's gonna pay something like that. But he accepted it and joined, you know, so kindly come to page 73. He joined on the dates are very important. Consequent upon joining of Prasad to the post of Southern Church on 11/7/2014. He joined on 11/7/2014. Now, Lord, next reference. But he has not filed that put some bail. He preferred an after joining, he preferred an appeal before the appeal authority. It was page 126. In 126, I will see we have the part line. Has preferred an appeal on 9/2/2015. After near about 1 year of joining, preferred an appeal. So appeal authority passed an order, but he was asking how this has happened. However, interfere with the order of this authority, they were going to be headquarters. These the first, third. Now you should kindly come to the requisitions.
What is the time in the regulation for filing an appeal?
That is 45 days. Now you should kindly come to the requisition when the requisition was filed. Page 31. You should kindly come to the page 31. The affidavit page is there. 18th May 2016.
Page
31 of the paper book. The affidavit portion.
For what?
18th May 2016 has been account and the requisition has been filed. After joining, after order, after joining, after applicant dismissal, requisition has been filed. Now, what is the challenge? The challenge is you also kind of come at page 22 of the paper book. Paragraph 20. Paragraph 20. Being aggrieved by and dissatisfied with the manner in which the petition has been treated for the period of circumstance as a rate of reinstatement and consequence on fixation. Therefore, fixation has been challenged. Not the order of the disciplinary, not the order of the appeal authority. Nothing has been challenged. Only the fixation order. These flows from the order of the disciplinary. Now, my submission is he's a person cannot approve and reprove the same thing. He accepted this thing. He joined, has taken the benefit of service. Thereafter, after long time, they thought they appeal. Appeal has been disallowed. But after that, it comes to a read, not challenging the main of the disciplinary authority and appeal. But in that part, I am referring to judgments. One is 2011 10 SCC, page 420, paragraph 34 and 36. Well, approbate and reprobate, or the judgment said that the person cannot approbate and reprobate. Paragraph 34 and 36.
It is at which page of 1110 SCC?
1110 SCC, page 420. Judgment, first judgment.
Okay.
Second judgment is at 2035 SCC, page 470, paragraph 15 and 16. It clearly states that a person cannot approve and reprobate the same order. This is not separable. He has accepted it, taken the benefit, then check. But this is my subject. Paragraph 15 and 16. But the regulation, the leave has been regularized as per regulation 66.4. I have given a copy to your lordship.
66.4.
66.4.
You are relying on 66.4.
66.4. But trial court also relied on 66.4. And one of the last portion, the regulation and the regulation 8 sub B.
8B.
8B. This may also be the decision shall be final. 66.4 and 8. Last portion 8B shall be final. Amendment 66.4 shall be deemed to have been placed under suspension in the case similarly the repetition. Although there is no order of official order, is not required. The regulation says deemed to have been suspended. 64. Last but one, 2 lines. Well, after accepting this, he cannot ask for further benefit. Doing what I told same.
Which orders he has not challenged?
Well, he has not challenged the disciplinary authority's order. He has not challenged the appellate authority's order.
Which order of the disciplinary authority?
Well, page 71.
What is the date?
Page 71. Order of punishment order.
What is the date, sir?
The date is 8/7/2004.
He has sought quashing of that letter. You are saying he has not.
8/7/2004.
Yes, 8/7 he has sought quashing of that order.
But the paragraph 20 he has said, but before the ground.
In the prayer, he has in the writ petition he has prayed for quashing of that order, as well as the 30th October. He has only left the 2/4 order.
He has not challenged.
He has left the 2/4 order. Yes, appellate order he has not challenged.
And the challenge has been filed challenging the same after taking the leave.
Let us see the Honorable Single Judge's orders once. Anything else you want to add?
And only two things. Not 66.4 was placed into service. 66.4 does not apply in this case. It's a case of further inquiry.
Of the prima facie view that does not apply.
Now, to confer finality to the order passed by a disciplinary authority under 8B, then every order of an industrial tribunal cannot be assailed before a court of law, or an arbitral order, like that. So, not that.
Let us just see the Honorable Single Judge's order.
Yes, please come to page 170.
Volume second.
No, it's Lordship may straightway come to page 166.
So, second volume.
In the second volume.
And what is 70? The Honorable Single Judge has taken note of regulation 70 also.
But 70 is appeal. Period of limitation for appeals. Please come to the last paragraph of 166. The argument of the petitioner that no order of suspension was issued against him is misleading. Deemed suspension does not require issuance of a formal order of suspension. There is a basic difference between passing a formal order of suspension and a deemed suspension. An order of suspension could have been passed had the requirement of regulation 66(1) been fulfilled. Such is not the case here. Regulation 66(2), 3, 4 deal with deemed suspension. Regulation 66(2) and 3 are not applicable here as the petitioner was neither convicted nor detained in custody or placed under suspension. 66(4) is the provision that is attached in the instant case. FCI invoked the said provision to treat the employee under deemed suspension from the date of the original order of dismissal after the original order was set aside by an order of court and the authority decided to hold further inquiry against the delinquent employee.
No, there is no such decision.
There is no such decision.
In fact, not shown to us. There is no decision to conduct a further inquiry.
No, further inquiry is also.
Then the FCI is entitled to act in accordance with the said regulation. The contention of the petitioner that he did not apply for any leave and his leave cannot be adjusted in the manner as has been sought for is self-defeating. Had the FCI not regularized the said period with the leave due to the petitioner, then the petitioner was liable to be treated as absent for the entire period. FCI acted in favor of the petitioner by regularizing the said period from his available leave instead of treating him as absent from duty. Moreover, the petitioner has actually not worked for the period from so-and-so to so-and-so.
Let's just come to 8(7) order. Is that which page?
Page 71. Page 71.
And 9914 is there is some order of 9914 also. In compliance with the RO West Bengal Kolkata's instruction issued wide letter so and so dated 9914.
That is not available with us.
Read with the above referred order. Is this on record?
No, this is not on
9914. Page 73. Have a look at page 73.
Page 73.
19914.
The official instruction making absence in compliance with the RO's Kolkata. After the order, the regional office has sent an instruction to the district office. That's something.
Where is it on record?
No.
No.
And where is your letter of 27/3/14 written by you?
That's not on record.
Please come to page 72. The third 2-line paragraph, 1.5-line paragraph.
Prior to allow him to resume duty.
Yes. What did you request them to do? That is a very vital, relevant and material fact. It appears that that is the basis of the entire leniency shown to you. Because you obtained a certificate in 2011 and you produced that before them and you gave a letter also.
Yes, no, that is apropos page 67.
Yes. So what is that letter of 27/3/14? And why this relevant and material fact has been suppressed from the report?
Not suppressed, no, it's already on record for them.
Is it on record?
No, not in this paper book. Not in the opposition also.
It is there.
No.
No, not in the read, not in the.
You have filed an opposition
Yes.
But in this appeal,
before the writ court.
Yes, there is an opposition.
Which page?
That is at page 91. Second volume.
Disciplinary authority. Then disciplinary authority should disappoint. Related an application. 7/14. Very important. This is relying on the postcard certificate which he has obtained
On the basis of the certificate, subsequent certificate. Subsequent certificate.
within your settings. You must have said that I'm giving.
Have you said anything about that in your reports?
I don't believe not such. Had it been so, then not you would have found place. Not the tenor of the opposition does not reveal that something was there.
No, it is more than obvious. After a disagreement note was served, you were being heard. You said that, look, I have obtained a certificate in 11. Please allow me to resume. What did you say? Allow me to resume subject to any consequences you may impose, or allow me to resume dropping the charges, or allow me to resume at any cost. What did you say? And having said something like that, which is material, why you have suppressed it from the report? This is a relevant and material fact. This forms the entire basis of the leniency being shown to you. We don't know what you have prayed for any mercy, or you have said that I will accept this. Please accept the new caste certificate. I don't rely on the earlier caste certificate. Proceeding is not required. We don't know what you said. Or you said, what are you doing? This is pointless. I have a certificate, take it.
If your lordship comes to page 97, the stand of the respondents in their opposition, I just read it for your lordships. The writ petitioner received the said disagreement note and also filed his representation.
We have seen it. They have skipped that entire portion. But nonetheless, it is there in the order. And it is nobody's case that is an error of record.
It says the writ petitioner thereafter, in terms of the direction, he should have submitted the fresh certificate. The opposition said that the writ petitioner thereafter, in terms of the direction of the disciplinary authority.
Correct. This disciplinary authority's direction on your application of 27/3/14. Therefore, direction was later passed.
26th March, 27th March, 2nd April, then 8th April.
Correct. So 26, it was just being considered. 26 does not show any reflection of any letter. 27th, you have given a letter, all of a sudden everything changed. And that you have suppressed from the court. And you are saying
suppression, not it's not there. Not a question of suppression.
Either you have disclosed in your averments, nor you have annexed the document, nor you have said that there is a recording of such a letter which is an error. No such letter was ever submitted by the petitioner. Anyway, you can't, whatever is there, you cannot improve. Is there any averment in the writ petition about this letter? Please ask your instructing counsel to verify again. Any averment regarding this letter of 27/3/14?
No, not in the writ petition at least.
In your reply to the opposition?
The opposition does not also refer to this. Not I say that once I had filed my representation against the disagreement note, the authorities had decided, probably because of the points taken, there was no real disagreement reflected in the order.
That we understood. Therefore, we are saying why you have suppressed this fact. You're trying to make out a case that the moment I came up with my defense, they said, all right, you give a new certificate, we'll take it.
But at least not the sequence of events would not lead to an inference that there was a material suppression or something like that, because the
According to us, it is a most relevant and material fact.
The 2nd April letter shows that you are called for a personal hearing.
Correct.
So when I produced my document at the personal hearing, then they decided not to proceed.
That is a date fixed in the proceeding.
That's right.
That's
So
not called for. It is being going on since before. You have turned the event. This is the flashpoint, and you have suppressed it from the court. This is the turning point. From here, everything has turned. Next day, everything has turned. And you are trying to say as if this never happened, or it was of no relevance. Whereas the fact is clear from the way things are proceeding, the sequence of events is clear. Yes, take down. Heard the learned Hey, can you get it Xerox from the library? Can you leave it with us, one of you, the better copy for a couple of days? We'll get copies from the library and no, this one we are scared to keep. It is in, it will all fall, it will fall apart.
There may be few markings not there. Kindly condolences.
Doesn't matter. वो ले लो उसका स्पाइरल बाइंडिंग खोल के वो करेगा और फिर स्पाइरल बाइंडिंग make sure that it is not damaged.
দুটো থাকবে হ্যাঁ দুটো থাকবে
Leave one copy, why leave two? We'll get a set made. एक ही रखो. One you will have.
তার ওইটা দিন ওইটা দিন
Get 4 copies. Done.
তিনটা কপি লাগবে দেখে নাও
19. Yes, TV. You should be. Yes, sir. Yes.
Judgment is the second paper book.
Huh?
Judgment is the second paper book. Paper book 2.
There are
468.
468. 468.
My lord.
Second volume.
Second volume, my lord.
Yes. Yes.
May I please, Your Lordship? My lord, the petitioner was initially appointed as, my lord, Assistant Accounts Officer. And pursuant to the decision of the Board of Directors, my lord, he was promoted as Accounts Officer in 1994. He was allowed to continue as Accounts Officer up to 2008. My lord, just before his retirement, 1 month before his retirement, he was reverted as Assistant Accounts Officer. His pay was reduced and the entire money which he received as Accounts Officer, that was deducted. My lord, had I not been promoted as Accounts Officer, I would have got, my lord, the benefit of career advancement scheme. Kindly see my letter of appointment, page 46. Letter of promotion, my lord, page 46. Last para, my lord. Paper book 1, my lord. Last paragraph, my lord.
Yes.
Now, Your Lordship, kindly come to page 76. Lord, kindly, sorry, my lord, page 77.
There is a promotion.
This is reversion, my lord.
No, where is the promotion?
Page 46.
That's a promotion.
Yes, my lord. Upgradation in the scale of Accounts Officer, my lord.
Upgradation, not
Upgradation.
promotion. Yes.
On condition that, my lord, if I accept that, I would not be entitled to get the benefit of the career advancement
That
scheme.
we have understood.
But had I been as Accounts Officer, Assistant Accounts Officer, I would have got that benefit of what is the career advancement scheme.
So where is this? There must be a
Your Lordship, now kindly come to
staffing pattern. Where is this? Where is this post in the staffing pattern? Let us see. The rules must contain that it is a post which can be filled up by way of upgradation.
Your Lordship, page. Your Lordship, kindly come to page 180.
What is this? This is not a staffing pattern. This is some board meeting minutes.
Yes. Yes. Well, everything has been done by the board's decision because it is a corporation.
What is the date of this resolution?
It is, my lord, dated Your Lordship, kindly come to page 68.
Page?
Your Lordship, kindly come to page 168. It starts.
$14,981.
My lord.
So how can this be? Your order is prior to this.
No.
Your order is
no,
of 14/8 to 2001.
No, my order is, I was promoted in 1994, page 46.
Yes, it's
94. This is in 81. This is the board decision, my lord. My lord, kindly see page 54. The board intimated the government will have not to expend any money for my promotion. Department will bear it. Page 54.
You
my
are
lord.
working through a contractor.
No. It is a livestock corporation, my lord.
No, you were. Where is your regular appointment in the corporation? By which order? When you were appointed?
1990. 1980, my lord.
Where is that appointment order?
Hmm? 1980, but they have denied it that I have been appointed.
They have. That has been taken note of by the Honorable Single Judge.
Well, kindly see the order of
You
promotion.
are not a regular appointee.
My lord, appointee, my lord, kindly see.
Where have you said in the writ petition that you were regularly appointed against the sanctioned post after a due process? Where is this averment?
You will also kindly for a moment see page 46.
Please show us the averment in the writ petition. Only the averments will be supported by documents.
Yes, only I am producing. Your lordship, kindly come to page 59.
Yes.
This is also the resolution of the board.
Again, we are asking you, where is the averment in the writ petition that you were appointed after a due process against a regular sanction post after an advertisement? Where are these essential ingredients of appointment?
Your lordship, kindly come to page 12.
Let us see. All of a sudden, the petitioner joined. That is precisely what we are saying.
That has not been annexed, but they have not denied that I have been selected.
What will they deny unless you say that you were appointed after a due process? What will they deny? You have to say so, then they will deny. You say I was appointed. Anybody can be appointed by anyone.
Well,
Unless you make out a case that there was an advertisement, assessment of interest and merit, open advertisement, I participated, this is the result, I was appointed on such and such date. There was an advertisement of sanction post. What is there to deny? They have not denied.
You will also kindly come to page 106. You honey. What are you?
Thereby appointed provisionally.
Will you kindly see?
Yes, provisionally, purely on a temporary basis. What is this? No procedure in accordance with law. Somebody likes you, so you are appointed. And then you continue. And then you are upgraded to a post which does not exist. And then after you retire, you say, give me everything. Wonderful.
Well, this is the corporation, they created the post, they approved to the government for sanction.
Where is the power to create the post? Show us the provision. Where is the power for the corporation to create the post by way of a resolution?
I'm sure.
Without any government approval? You are not prepared, sir. Matter is adjourned. List after 2 weeks. We will not allow this. This consultation in courtroom, we highly disapprove. Come prepared. All the next. After 2 weeks.
720.
I beg to appear for the appellant.
I appear for the respondent writ petition, my lord, led by Mr. Bikash Ranjan Bhattacharya and Subish.
Respondent writ petition.
Respondent writ petition, my lord, led by Mr. Bhattacharya and
The order under appeal starts at page 86. Which is 870. Lordship, one request. Lordship, one request. If your Lordship kindly takes up FMA 870. Both are identical matters.
Why there are two appeals?
Two different appointees, my lord.
my lord, two different appointees terminated, my lord, from service.
So in
Factor
both
identity.
case, you are representing the writ petitioner.
Writ petition.
Both cases.
Both cases. Both the cases. Both are same, my lord, just date of appointment and these.
870, you want us to go through 870?
Yes, my lord.
Page 86, this is the order under appeal.
FMA 870 paper book.
Money. 870.
Kindly take up
870.
FMA 870. পরেরটাতে কিছু পেপার মিসিং আছে, এটাতে সব পেপার আছে।
870 তে?
হ্যাঁ,
জানি ওই জন্যই এটা দেখে।
নেক্সট ওয়ান, পরেরটা।
So give us a brief outline. What has happened? Please tell us why you are here.
My lord, here the moot question is the writ petitioners were appointed. They were initially on probation, subsequently confirmation. They were appointed. And my lord, during the interregnum period, there was a complaint which was received by the head office of the authority which I am representing.
During their probation period?
No, during the period between the probation and their confirmation.
That means
Yes,
during
during probation. During probation.
Yes.
So they received a complaint whereby it was alleged that certain irregularities had crept into the recruitment process. Now there were.
It was not a specific complaint against them. It was a complaint
A
regarding
general
the
complaint.
process.
A general complaint. Now it was inquired into. There were two inquiries which were held. One at the behest of the regional office of the authority and the other by the vigilance department, because the letter was received by both the departments. Now the one which was received by the regional office, that ultimately called into a report whereby it was observed that their appointment had been regular. But the one which was probed by the vigilance department, a number of factors were drawn out, where on the basis of which a formal investigation inquiry was also conducted. And upon the inquiry, my lord, the services have been terminated.
Inquiry was conducted with reference to which charge? What was the charge against them in the
My lord, the charge was, there were two charges. Formally, there is a rule, my lord, where an entire disciplinary proceeding need not be carried out. But the charges were that there was nepotism involved. Number two was the technical test, which is the typing test. There was a gross error because they had fallen short of the prescribed limit, which was expected of the appointee. So these were the 2 points.
The charge memo is identical in both the cases.
My lord, there is no charge memo. That is one of the contentions which were raised by the writ petitioners. My lord, the rules provide that if, apart from the rules, my lord, it is also a provision which I will be demonstrating, that if the appointment is illegal and there has been some lacuna in the recruitment process, then that ipso facto gives rise to an order of termination without a full-fledged disciplinary
So
inquiry.
they were the only two persons who were recruited in that process?
Yes, my lord, only two.
And why you say nepotism? They had relatives?
They had relatives.
Who are their relatives?
My lord, relatives subsequently, my lord, since they are superannuated, so disciplinary proceedings were proposed, but it could not be conducted.
So they were not proceeded against.
They
The
could not be
beneficiary
proceeded.
was
Subsequently, my lord, there were a representation made to the
Let us try to understand. We'll hear you, don't worry.
My lord, we had also made a representation to the Central Bureau so that Central Bureau of Investigation, Central Bureau of Investigation, since it deals with the central authority to inquire into the matter. But however, there was
Which
a judgment in
organization?
vogue.
Central Warehousing Corporation.
Yes, my lord. So there was a judgment in vogue where your lordship would remember that it was held that since the CBI draws its power from the Delhi establishment Act, the Delhi Police Establishment Act, so it could not inquire into all the
Where
offences.
is the order removing them?
But
What
the
is the
order is at
consideration?
page 86. Oh, order removing. I'm sorry. Order removing is at page 41. Appended to a memorandum dated 12/3/2018.
The typing test sheet, is it there on record?
My lord, that is part of the inquiry report that is appended to my application for additional evidence.
Page?
Typing test. My lord, the evaluation sheet.
No, sir. You read the third paragraph of this order at page 41. There is a typing test sheet.
Yes, yes.
Which you say we revalued and we found that undue marks were awarded.
My lord.
So where is that typing test sheet? And how a conclusion can be arrived at behind his back? That is what we are trying to see.
My lord, there's one more point which I would have demonstrated that there is a scope
After the first point, you will urge the other point.
My lord, that is linked with this. My lord, that is linked with this. There is a scope of a review. Any order could be reviewed before the higher authority. My lord, if he would have preferred an application for review of the order, my lord, then we would be bound to produce them the documents that they are asking for.
But not before the writ court.
No matter the difficulty, I tell you, lordship.
Show us, where is the typing test sheet? See, there are two things. One is if he is under probation.
My lord.
A remover, simplister.
Yes.
Then it may have been different.
Yes.
You are casting aspersion on him. He is out of the job market for all times to come. No proceeding conducted against him.
My lord.
No inquiry conducted against him. No charge memo.
My lord, this
order.
order.
Some employee indulges in nepotism. He is let free. And they are, how it can be?
My lord, this order would not cast any stigma.
Why not? Just see.
Because
ineligible for appointment. So he has obtained an appointment though he was ineligible. What else is the stigma?
My lord, ineligible to the extent that he could not come up to the yardstick which was prescribed for the technical test. That is the typing test.
That is not the point. This is a finding which visits him with stigma. How it can be substantiated? Where is the order of the Honorable Single Judge?
In 91 it started.
How he had become a permanent employee?
But subsequently he was confirmed.
Confirmed?
Yes, my lord, confirmed.
And then you have passed such an order. What is the date of confirmation?
Date of confirmation of that. My lord, it was 27th May 2016. May I tell you, lordship, the relevant dates? Offer of appointment was given on 9th of February 2015. Letter of acceptance to the offer was 12th of February 2015. The petitioner was put into probation on 3rd of September 2015. and confirmed on 27th of May 2016. And termination was issued on 12th of March.
12th March 18. There must be a conduct and appeal rules in the corporation.
Yes, my lord.
Which provision supports passing of such an order?
My lord, the order has been passed in.
It is under which provision?
Rule 20. Lordship, can
Yes,
takes up
regulation 20. Regulation 20. Where is regulation 20?
Page 46. My lord, may I place the rule?
Oh, we are reading. It is under which provision? 20? A, B, C, which provision?
Sub-rule 1.
There is a notice given.
No, my lord, there was no notice. Notice is the notice period, my lord.
Sir, under which provision you refer to section 20, regulation 20?
2020, sub-rule 1.
What is 21?
Except as may be specifically provided in the contract of service, the corporation may at any time discharge an employee or terminate the services of an employee by giving the following notice.
So therefore we asked you, has any notice been given?
Yes, notice was given.
Where is that notice?
I'll show you.
This is a provision for a simplistic termination.
It is likely for a probationer.
That is resorted to if an organization is being wound up or there is no work or something like that, that you give a notice in terms of the provision and you ask him to go home. This is not a provision which can be invoked to pass such an order that you obtain an appointment, though you are ineligible, we have verified everything, you are ineligible, go home. This is not 21 order. Therefore, we are asking you under which provision you have passed the order.
My lord, one indulgence if my lord, one indulgence, my lord. If your lordship takes it on Monday, tomorrow I have a difficulty, my lord. I'll be going out for treatment. Monday, preferably on the top. I don't mind if it is taken up out of serial.
Yeah, you'll not keep it on mind. The Bhattacharya.
Further clarification.